Get back.
Nobody in the clerk's office is here. We'll have to be delayed. We were a little early.
One of those conference rooms.
Okay.
Yeah, it used to be afternoon. I guess she's going to put out 30 days. I don't know. I wasn't in the mood to start going through
I
them.
bet you they didn't bring it all, but I don't know what.
Okay, let's go. This docket's here.
Most of it's. I know I'm going to get out here. Free papers there.
Stephen Brown. You don't have, he hadn't been transported?
Mr. Lee Davis represents him and he is here. He spoke to me this morning and said that he thought he was in Barron County Jail. There's a Stephen Brown there. He is there, but he's actually a Christian. It was the wrong Stephen Brown.
That's correct. He did the wrong transportation order for the wrong Stephen.
The
Brown.
wrong Stephen Brown.
So you want to pass over?
Well, yeah, I guess we just need to continue it till next month with a negotiation day, because Mr. Davis' first appearance on
What is the negotiation date next?
June 6th at 9 a.m.
Negotiation date, June 6th at 9 a.m. Next court date, June the 12th.
I'm sorry, what was the, what is the court date?
June the 6th for negotiation at 9 a.m.
Yes, sir.
and June the 12th. Next pretrial conference.
Your Honor, I've got a scheduled trial that day, but I think that's going to
Which
not
day?
go through
Which day?
well, it starts the 11th and.
Talking about the
but it's-
12th. You're talking about the 12th.
Yes, it's going to go through the 12th, but it's likely not going to go. So,
Claude Kevin, Commonwealth versus Claude Kevin.
okay, thank you, Your Honor. May I be excused?
Yeah, absolutely.
Thank you.
Commonwealth versus Claude Kevin. Are you Claude Kevin?
Yes, sir.
Good morning. Were you born in 1998?
Yes, sir.
Last four digits, social security number 0475.
Yes, sir.
We're on 24 CR 0082. It says probation revocation. You want to come around, Mr. Stockton?
Yes, Your Honor. Mr. Cannon had 7.5 years on bribery for a public servant. He was placed in drug court in Allen County, was discharged, and I have the lady here to testify.
No stipulator.
No, Your Honor, we want to have a hearing.
Oh, you don't want to stipulate? Okay, we'll call your first witness.
Samantha Neal.
Okay, you gonna come around? You can just stand right here if you want to. You raise your right hand, please. You swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes.
State your name and who you're employed in what capacity.
My name is Samantha Neely. I'm the Program and Recovery Coordinator for Allen and Simpson County Drug Court.
Thank you. You may proceed, Mr. Stockton.
11 years.
Okay, so you're familiar with the defendant Claude Kevin,
Yes.
and did you orient him or did he started in drug court in Allen County?
Yes, he was actually a transfer from Monroe County. So we accepted him as a transfer on March the 3rd of 2025, and he attended orientation with us on March 5th of 2025.
Okay, and was he terminated from drug court in Allen County?
He was.
And what date was that?
March 26th of 2025.
So he was only over there for about 21 days?
Yes.
Okay, why was he terminated?
His transfer was accepted contingent upon his placement at a sober living home in Allen County called the Dream House. That was the only approved home placement for him there. And he was unsuccessfully discharged from that placement on March the 25th.
You know, why he was discharged?
He refused to stop driving even though he didn't have a license.
That was my next question. So while he was at the sober living house, he continued to drive.
Yes,
Did you get complaints from individuals about that?
I did.
From what, was it private individuals or law?
Private individuals.
I have nothing further.
I have a few questions, Your Honor. Ma'am, with regard to the driving without license, did you ever witness Mr. Cavan drive without license?
I did not, but he did admit to me that he was.
Okay. And with regard to the sober living home, did drug court attempt to help Mr. Cavan with alternative living placement?
No, we accepted the transfer from the other county based on his placement at that sober living. It's the only sober living home in Allen County.
So why did the Allen County Drug Court terminate him instead of send him back to Monroe County, who had sent him to you all?
That's not how our process works. Once a transfer has been transferred, then the process is they either complete that program, are administratively discharged or terminated, and then the case is sent back.
So with regard to drug court, was Mr. Cavan otherwise complying with drug court?
No,
Do you know if the Dream House would have taken Mr. Cavan back?
they would not, or at least that's what they told me.
I have no further questions.
No redirect.
May she be excused. Thank you for attending. You have any other witnesses?
I do not.
Would you like to call a witness?
Yes, Your Honor, Mr. Cavan.
You raise your right hand, please. You swear the testimony about to give the truth, the whole truth, and nothing but the truth.
Yes, sir.
State your full name, please.
Claude Cecil Cabin Jr.
Mr. Cavan, can you explain to the court the issues you are having with housing at the Dream House?
I had self-terminated myself because I was having an issue, there. I did drive to work one day and, when I did, they found out about it and they confronted me about it, and I didn't like the fact that I was confronted about it. And, so I had subjected to leaving, and they said that that was fine. And I had called Miss Samantha. I called her, told her what was going on, and I told her that I had another placement, but it was through Bowling Green, one of Brad Sowell's home placements. And I had explained to her that moving to his house, I would have bus routes and things to get to work. And while I was trying to get that worked out, I come back to Monroe County, and I stayed the night at my father's.
Why did you come back to Monroe?
I didn't know if I was gonna be transferred back into
Okay,
the system here, because when they terminated me, she said to come up here the following Monday. And I showed up and I went to Larry Graves' office, and I sat outside his office for a couple hours waiting to find out what was gonna happen.
okay. With regard to housing in Allen County, did you have anywhere else to live other than the Dream House?
Not in Allen County, no.
Okay, and, did you have housing otherwise?
Yes.
Where at?
Back here in Monroe County at my
Okay.
previous address.
Okay, and what are you asking the court to do today?
Well, drug court was helping me. It really was. The AA meetings were helping. Being able to be a part of that community was forming me into a different person. And the fact that I didn't take accountability at the time that I got terminated, really changed my perspective on a lot of things. And now that I'm taking accountability now, I was hoping to maybe either get a chance to go back into drug court here in Monroe County, go back to my previous address, or get sent to a long-term treatment.
And do you believe that you could be successful at drug court this time?
Yes, ma'am.
And if drug court was not an option, do you believe that you could be successful with long-term treatment
Yes.
and on supervision with the probation office?
Yes.
I have no further questions.
Mr. Caven,
Yes, sir.
were you in jail until you entered the Monroe County Drug Court on this case?
Yes, sir.
And when was you released from jail?
It was December 17th of 2024. I
Okay.
believe.
And so you were in drug court in Monroe County for about 3 months before you were transferred to Allen County?
Yes, I was in here for it was about 3 months or so, and
And I'm curious, since I don't attend the drug court down here on Monroe County, you was there for 3 months. Did you have violations, the reason you were transferred to Allen County?
no, I asked to be transferred to Allen County. I was thinking it was gonna be better for me being in Allen County, and I guess I was
You were
not
wrong,
correct.
I
I was not correct.
Yeah, okay. So you voluntarily wanted to go to Allen County and live in this sober living house?
Yes, sir.
Okay. And you never had driver's license the entire time after you were released from jail? Okay. And you said you drove one time?
I did.
I have no further questions. Your Honor.
Let me redirect.
No, Your Honor, but I would like to make an offer in lieu of revocation. I'd like to make an argument in lieu of revocation. Your Honor, I'd ask the court to not revoke Mr. Cavan and instead give him another opportunity to be successful on probation, either through drug court if he were to be accepted into the program again, or through long-term treatment with supervision by the probation office. Mr. Cavan was in drug court from December through end of March. Testimony here today says that he shows he did not do very well in Allen County like he expected to while he was on supervision by the drug court. He had some issues with transportation as he did not have a license. He had some issues with housing once he was kicked out of the sober living program. He has testified this morning that now has a new perspective after everything has happened and would be willing to comply with the terms of either drug court or long-term treatment with supervision by the probation office. And I would ask the court to not revoke him and instead give him another opportunity to be successful on probation and with his recovery.
You want to move to the left a little bit here.
Yes, sir. Sorry.
This case originated because Mr. Cavan was in a bad place. He was on synthetic drugs. He got into the residence of Jackie Wheat, who found him sitting in his truck. He busted out the glass to gain entry. Then he got into a Evangeline Bray's vehicle where she had her infant child strapped in the back and attempted to leave that vehicle with the baby in there. So he ended up pleading guilty because he offered the officer like $10,000 to let him go or something like that after all this happened. And he was placed directly into the Monroe County Drug Court program based on his actions and his plea to try to get a handle on this so he wouldn't repeat his conduct. Mr. Cavan's made some bad decisions here by asking to be transferred to Allen County in this case. He would probably still be in Monroe County Drug Court maybe doing fine if he hadn't done that, but you don't get two bites at the apple on this on the drug court program. And it's the Commonwealth's policy, and it always has been, if you're terminated for the drug court program, the Commonwealth asks for revocation.
Did he go in on a plea or a
He went
diverse?
directly in on the plea. He went in front after.
He did a felony plea.
It was a felony plea, 7.5 years sentence.
Anything else?
Judge, I still maintain my argument, but ask the court to not revoke, give him another opportunity.
Well, here's the thing about it. You know, drug court is not a right. It's an opportunity given. It's a break given. And, you know, he wasn't supposed to drive. These are vehicle related situations. He wasn't supposed to drive, didn't have a license. He just violates the thing. And then this argument about where he came and he was doing this, it's just, I just don't think he can be compliant from what I hear in the thing. So I'm going to go ahead and revoke him. And I guess he would be eligible for shock at some time. Is that correct? So I would consider a motion for shock at some time. But, you know, these people have got to comply. If we let everybody just do the way they want to in drug court, come and fro, and then, I mean, there's no reason to have it if they're not compliant. So thank you very much. Timothy Curtis. Timothy Curtis. Are you Timothy Curtis? Good morning, It's Commonwealth versus Timothy Curtis, 25 CR 004. Mr. Curtis, were you born in 1978?
Sir.
Last four digits, social security number 1511.
Yes, sir.
We're here for a pretrial conference. What do we have?
We have a felony plea, Your Honor.
Motion has been filed that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily get given?
Yes.
Hey, are you the person that we just identified in the indictment?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with her advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial of the jury, the right to be represented by counsel, the jury trial, the right to confront and cross-examine all witnesses called against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you.
Sir.
You understand that if you, by entering this guilty plea, you give up those charges. You understand that?
Sir.
And I may consider the Commonwealth's recommendation, but I may apply a range of penalty provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll await a pre-sentence investigation report to be done by probation and parole.
Yes,
In the
sir.
event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial.
Yes, sir.
You move to your left here, sir. Move to your left. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to trafficking in a controlled substance, first degree, second offense, the defendant shall receive a sentence of 20 years. Upon a plea of guilty to criminal mischief, first degree, and persistent felony offender, second degree, the defendant shall receive a sentence of 10 years. The 10-year sentence and the 20-year sentence shall run consecutively for a total of 30 years. Probated for 5 years, supervised. The defendant shall enter and complete a long-term treatment facility provided by DPA and agreed upon by the Commonwealth. The defendant is currently incarcerated and shall not be released prior to final sentencing. The defendant shall remain incarcerated until the morning of the bed date. Probation and parole shall transport the defendant to the rehab facility. The defendant shall receive credit for time served. The defendant shall pay restitution in the amount of $1,000 at a monthly rate of $100 payable to the Monroe Circuit Court Clerk, with first payment being due 30 days after being released and due on the same date thereafter. Restitution is subject to a 5% clerk's fee. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws, the Commonwealth, and the holding agency. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You doing so of your own free will? Doing so of your own free will?
Yes, sir.
Knowing your constitutional rights, explain to us it's still your desire to give up those rights, enter a plea of guilty, and allow the court to fix your punishment or range committed by law.
Sir.
Okay, you understand by entering this plea, any future convictions will be enhanced further under the persistent penalty offender law.
Yes, sir.
Is that your signature?
Yes, sir.
I'll accept the agreement order pre-sentence investigation report, schedule sentencing for June 12th. Dwayne Flowers. Dwayne Flowers.
Oh, Robert, she's got your Christmas card too.
Come around, Mr. Flowers. Come on around here. Come on up here. Are you Dwayne Flowers? Good morning. Mr. Flowers, you're here on 20 CR 0082, a pretrial diversion revocation. Were you born in 1973? Last four, you're gonna have to say something. It's a voice. Okay, let me hear you. Okay. That's what gets the camera on you, what the noise does. You see what I'm saying? It's a voice activated camera. The last four digits, social security number 0177.
Yes.
We're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, Mr. Flowers had a 5-year sentence on theft by unlawful taking. He was being supervised, and then in September of 23, he left the state from supervision, went to Texas, and that's where he was extradited from. So he's been absconded from September of 23 through May of, or April of 25. That's the info.
Judge, we're asking for a hearing.
Are you with us?
Oh, Mr. Collins.
Raise your right hand, please. You swear the testimony you're about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
Okay, Mr. Stockton.
Mr. Collins, looked like he, Mr. Flowers began supervision sometime in September 2021. Is that correct?
Yeah, it was the supervision began 6/17 of 21.
Okay. And then what happened in September of 23?
So in September 27th of 23, well, let's back up and go from December of 2022.
Okay.
So on 11/8 of 2022, Mr. Flowers reported the address of 117 Countryside Drive, Apartment 4, reported telephone number of 270-779-7989. He was given the next report day of 12/13 of 22 at 10 a.m. On 12/9/22, Officer Ryan Cowles attempted to call subject, scheduled to reschedule his report day, did not answer his phone, and no voicemail was set up to leave a message. Mr. Flowers did not report as originally directed on 12/13 of 22 and did not call to explain why he could not report. And on 12/19 of 22, Officer Cowles and Officer Pitcock attempted to contact Mr. Flowers at his reported address. They did not make contact with anyone at the address, left a door tag directing him to report on 12/20/22 at 9 o'clock. He did not report on 12/20/22 as directed by the door tag. That officer conducted a justice exchange and called medical centers, could not find him or locate him. And then he was charged with absconding there, and what looks like probably a warrant was issued then for absconding.
Then it looks like the
Yeah.
last contact with Mr. Flowers in September of 23.
And on 9/27 of 23, Mr. Flowers called from a telephone number, which was the number given previously, stated that he was currently homeless in Dallas, Texas. He stated that he ran off from Kentucky because he was scared that a man in Kentucky was out to do harm to him. He stated that he knew he had messed up and did not want to go to prison. He advised subject that he would need to turn himself in on the warrant to get back to Kentucky. Subject was resistant to this idea and asked if he could make things right without having to go to jail. Officer Cowles advised him that as long as this warrant was active, the worst it would be on him to appears for his revocation hearing. He was given again directive to turn himself into local law enforcement. And then Officer Cowles called KSP Post to verify that he was entered into NCIC.
So I was wrong a while ago. It's even worse than I thought. Really, the last contact where he reported was October of 2021. Is that correct?
From what I see, correct.
Okay. So really probation parole, other than the one phone call, has had no contact with him since October of 2021.
Correct.
Yeah. Thank you.
Ask some questions, Your Honor.
Sure.
Officer Collins, the first missed appointment was December the 13th.
He last
2022.
Yeah, he last reported on 11/8 of 22 and was given a next report day of 12/13 of 22, and he never reported after that.
Okay.
Yeah.
And so up until December the 13th of 2022, Mr. Mr. Flowers was otherwise compliant with probation's expectation of meeting with him.
Well, not entirely. On 9/16 of 21, looks like he was asked to provide a sample for drug testing, field tested positive for THC, and he admitted that he used an edible on 8/26 of 21 and signed an admission form for that. And it looks like that's the only problems he had prior to
Okay.
that.
And with regard to that, to the incident with the THC, did probation sanction him?
We did. For a marijuana positive for the first time, they're required to complete a marijuana education homework packet. It was supposed to be turned in on 10/14/21, and I'm not sure if that ever got turned in.
Okay,
So,
but you also don't know if it was never turned in.
correct.
Okay. And just to establish, you did not personally supervise him?
I did not. This officer's no longer with the department. So,
Okay. And I missed what what date it is that the report was finalized. What was the last report? When was it finalized?
The last report was finalized on 9/27 of 23.
So do you have any information about any potential contact between probation and Mr. Flowers after that?
The last contact that was made was notated by this officer on 9/27 of 23.
I have no further questions. Thank you.
Yes.
No redirect, Your Honor.
You have another witness?
No other witnesses.
Your Honor, I'm going to call Mr. Flowers to testify.
Raise your right hand, Mr. Flowers. You swear the testimony about to give us the truth, whole truth, and nothing but the truth.
Yes.
You may proceed.
Mr. Flowers, can you explain to the court why it is that you missed a report date on December the 13th, 2022?
Thought I was okay. I talked to the probation officer about being sent to Texas because I have family there, and there was problems here with a couple of people. I said, no, I don't want to be involved in this, and there was actually like serious wanting to do harm to me.
Okay.
So I talked to the probation officer and thought that I would be transferred as unsupervised probation in Texas. It got worse. I had to call the police to help get escorted away from there safely. So when I got to that happening, I went on and got on a Greyhound and I left here. So where I could be safe around family. When I
Okay. And
did contact Officer Cowles, apparently that wasn't the case of him finishing out me being transported.
And with regard to Kentucky, did you have any family in Kentucky?
No,
Okay, any support system in Kentucky?
no,
Is the only support system or family you have, were they in Texas?
they're in Texas.
Okay. And can you explain to the court, why it is you did not come back after September the 27th, 2023?
After which date?
September the 27th, that is when, probation last had contact with you.
September, October. I was supposed to be back to see him till like October
No, 2023.
of 23.
Yeah, when you were in Texas and you spoke with the probation officer at that point.
I was trying to get enough money because at that time he was saying that I might be going to jail. So I was trying to get enough money to get an attorney.
Okay.
I've been working, actually a salesman at Toyota.
Did you intend to make your whereabouts unknown to probation?
No, he the whole time knew of my address in Texas. He knows that that's my family.
Okay,
And when I told him that I was homeless, is because I didn't want my family directly involved with what I had going on. But
Okay.
he has the address of my sister and where I've been staying since I've gotten arrested this time.
okay. And with regard to the address to probation, if you were to be offered another opportunity to be on probation, would you comply with the rules and regulations of probation,
Yes,
including reporting?
yes.
Is there anything else that you would like the court to know?
Sorry to misunderstanding, but I'm okay with following the laws of the probation. That first time was a mistake. Thought that it was candy, wasn't. But each time after that, I passed each drug test.
And Mr. Flowers, had you been on supervision before?
No.
Okay. I have no further questions.
I just have one. Who was threatening you, Mr. Flowers?
Some members of a member of Hamilton family.
What was the name of the person?
He's deceased now, Marcus Hamilton.
Hey, why was he threatening?
Because I'm was with and still talk to now his ex-wife. We were together even when the incident of me being in jail. Drove her car to court, but I was accused of taking her car somehow. And now I've said, okay, I couldn't afford an attorney. I took the consequences of probation and followed probation.
Did you move to Texas because you were afraid of this transit?
it would have been phone threats, and I still have on my Facebook and messages where he was threatening me over there on my Facebook.
I have no other questions.
Your Honor, I have no further questions for him, but I would like to make an argument in lieu of revocation.
Okay.
I would ask the court to not revoke Mr. Flowers. He came on to pretrial diversion in June of 2021 and did have a positive test for marijuana in September of 2021 that probation issued a sanction, including a marijuana education packet. There were no
Was his
further.
pretrial diversion revoked?
This is.
This is, so it, when she
It's
said,
been pending now for, I guess, 2 years, over 2 years.
okay, go ahead.
Okay. The next violation occurred, with regard to the failure to report on December the 13th, 2022. So up until that point, he was relatively compliant with probation and showed that he could be, managed in the community, that he was not a danger to the community. Mr. Flowers has testified to the court that he became afraid, that he was being threatened here in, Monroe County, that he had no support system here in Monroe County or in Kentucky, that everybody that he knows is in Texas, that he had contacted his probation.
So I don't understand what the testimony is. Is he just left and he told his probation officer he's leaving?
Judge, it is my understanding that Mr. Flowers misunderstood how the interstate compact works and believed that the discussion with his probation officer was good enough at that point for him to go to Texas. And he believed that in Texas
Well,
that he would be.
did he have any
unsupervised.
contact with probation and parole in Texas?
Judge, he did contact his probation officer in
Texas,
September of
he said he
2023.
thought he was getting transferred to Texas. Did he have any interaction with probation and parole in Texas?
Judge, I am
I'm
unaware if
asking
he
you,
has.
I'm gonna be like a congressional person, yes or no? If you don't
I
know,
don't know.
okay, well, he had opportunity to tell me and he didn't. Go ahead. Do you have anything else?
Now, this is a sad case because Mr. Flowers seemed like a reasonable person. If he had just went through the process and requested an interstate compact transfer to Texas and stayed here until it was approved, he would probably been approved. But you just can't go willy-nilly and do what you want to, and just, these probation officers have a hard enough job trying to keep up with everybody without people not being cooperative.
And Judge, I would like to point out to the court, this was a pretrial diversion. Mr. Flowers had never been on supervision before, so he would not be as familiar with the rules and regulations of probation as someone who had been on
You
it.
don't know how familiar he was or wasn't.
He qualified for
didn't
a
test-
pretrial diversion, Your Honor.
Yeah. Everybody just about does pretrial diversion. I'm not buying. The fact that you just leave the state and aren't in contact with anybody and you think everything's cool. And then you have to be extradited back to the state. I'm just not buying that. What I'm gonna do is I'm gonna revoke the pretrial diversion order, pre-sentence investigation report to be done by probation and parole. And then we have the sentencing on June the 12th, and I'll take it, once we see this report, then I'll take a look at whether I probate him or not.
Thank you.
He seems like a fairly, potentially a good prospect for probation, but, we'll see him then, okay?
Thank you, Your Honor.
Yeah. Derek Graves. Elmo versus Derek Graves, 18 CR 00176. Are you Derek Graves?
Yes, sir.
Good morning. Were you born in 1994?
Yes, sir.
Last four digits, social security number 1206.
Yes, sir.
Okay. We have a probation revocation. You will call your first witness, Mr. Stockton?
Yes, this is the Commonwealth's fourth motion to revoke probation, not Mr. Collins.
Okay, y'all move over this way, sir.
Yes, sir.
Raise your right hand and swear to testimony about to give us the truth, whole truth, nothing but the truth.
I do, Your Honor.
Go ahead.
Where do you want to start at, Mr. Collins, as far as the rights violation? Yes.
That'd be fine.
Okay. Could you go ahead and
Yes,
detail Mr. Graves' violations?
I can.
What they could do.
Yes. Officer Timothy Norton was supervising Mr. Graves. At the time, this violation occurred. On 12/9/24, Mr. Graves was seen at the probation and parole office and given an next report date of 1/9/25. Graves did not report on 1/9, did not have a cell phone, which prevented Officer Norton from being able to call him. As of 12/9/24, or I guess it would be as of the date of the report of 1/21/25, Graves still not made contact with probation and parole. Failed to report changing home address to his parole officer on 1/17/25. Officer Norton attempted to contact Mr. Graves' his last reported address at 509 Dennis Way, apartment B1, which was the Soki sober living home. A new resident answered the door and stated that Graves had moved out weeks prior and not been heard from. So officer did not know the current location of Graves. He had failed to make contact or update his current address. Next violation was absconding. After Graves failed to show up for his scheduled report day on 1/9, Officer Norton attempted to make contact with Mr. Graves via phone. However, Graves did not have a working phone. An attempt was made to contact Mr. Graves' last reported address on 509 Dennis Way, and it was discovered he no longer resides there. He had not provided any phone numbers, emergency contacts, or relatives. Checked Justice Exchange and jails, hospitals. They all yielded no information. Then a probation violation warrant was issued for absconding then.
When was the next time then Mr. Graves was heard from him?
On 4/23/25, Mr. Graves was arrested and charged in Monroe County case number 25M 42 for fleeing or evading police third degree and alcohol intoxication in public place first or second offense.
And what did the memo say that the officers?
Um, Officers went to 309 Dillon, Officer Deputy 309 Dillon Victory went to attempt to serve a bench warrant on Mr. Graves. Upon turning onto Brandon Road, they spotted Derek in red shorts and a white T-shirt standing outside beside his dad, Billy Graves. We approached Derek, as we approached Derek, he reached his hands into the front of his shorts and took off on foot towards the woods. Myself and Dylan went on foot, pursued after him. After clearing the shed that Derek ran behind, by the time we got in the woods, we lost sight of him. Deputy Geralds arrived on scene about an hour later, and all units went to the edge of the field by the woods, and Mr. Graves was located in the woods, hiding under trees. Mr. Graves had a strong odor of alcohol on his person. He was arrested without incident and transported to the PD.
No further questions.
Just one question, Officer Collins. Are you aware of what the ultimate resolution was to that new misdemeanor case?
I'm not.
No other witness.
Do I call witness?
Yes, Your Honor, if I could call Mr. Graves.
Raise your right hand, sir. You swear a testimony about to give us the truth, whole truth, nothing but the truth.
Yes, sir.
Derek, can you tell the court what it was that was going on in your personal life that led to these violations?
Well, I went to sober living and I went to actually two of them. I went to Gateway and it was seasonal, so I couldn't get no job at the time. So I stayed at Gateway till they kicked me out. So I went to Soki. And at Soki, I stayed there, still tried to get a job. Couldn't find no job. They kicked me out 2 days prior to Christmas. Told me either go to whatever you call it, a Salvation Army, or you're on your own. So I went home. I actually contacted Norton on the field and told him that I need to change my address to Monroe County because I got kicked out of Soki living. And well, he said, I explained to him that because my mother just died September, and then my grandma died that day on the field when I called. So when I told him that, he said he's going to he said, okay, we'll just leave you in the system. And
I mean, we got a lot of hearsay going on here. I mean, I'm not.
Hearsay, Your Honor, generally the rules with probation hearings are that
We
hearsay.
generally
isn't
are,
allowed.
but you know, we have hearsay on top of hearsay on top of hearsay. I mean, but I'll let him go on. Go ahead.
I just think what's relevant is
Yeah, I don't understand.
the actual violations that we put before the court.
Your Honor, the allegations are that he absconded from probation and parole. We are currently trying to explain to the court
Why?
what was
absconded?
going
Yes.
on
You're-
with his
so
housing
you admit he
situation.
absconded, you admit he absconded, and now you're trying to explain why he absconded.
Your Honor, we're
right? Is
trying
that
to-
right?
We're trying
Is that
to,
correct?
that is not exactly correct, Your Honor.
Not exactly.
Yes.
Okay, well, go ahead then. I want to be exact.
And I talked to Officer Norton, like I said, on the 5th, and then he called again, my grandmother on the 17th, because I told him on the 5th, I didn't have no working phone and what was going on. And they said that it was okay, just stay in contact with him. So when he called back on the 17th, my grandma was actually in the hospital, so when he talked to her, I didn't get to talk to him back to the 22nd. And then he explained to me what was going on. And then I ended up getting a fungal infection, so I ended up actually going to the hospital myself and staying for 4 or 5 days. And then they treated me, they actually made it worse because they gave me infection pills, and it actually makes a fungal infection. I know you probably don't.
We're following this.
I'm just explaining to you how it led to the situation where it was at, but
I don't know. Let's go, move on.
move on.
Yes, Your Honor. Derek, can you tell the court what your plea agreement was on that new misdemeanor? case?
PI,
On the
Yes.
AI charge, not on the pleading and evasion.
not the pleading invading. I did not plead invade.
Those are all the questions that I have.
I have no questions.
You'll make statements.
Your Honor, at this time, Mr. Graves is asking for the court to allow him to remain on supervision. He would be willing to go back to another sober living residence or other treatment program as the court requires.
Let's comment on that.
Well, Your Honor, this is an 18 case. And it looks like he's been supervised since December of 18. His probation's been extended. This is the Commonwealth's 4th motion to revoke. He's had various, just about every type of violation between now and then. And then he absconded, and he can't be accused of not knowing how the process worked. If he got kicked out of that sober living home, he should have went directly and reported to his officer and made arrangements to get this done. Instead, he goes into the wind and then runs from the officers when they catch him. You know, if he's not revoked, might as well just let him go and do what he wants to, because that's what he's doing anyway.
Okay, well, this time you got this behind you here. I'm gonna revoke you and just you'll be eligible for parole pretty soon. You know, and that'd probably be a less restrictive supervision and better for you than this probation. You haven't done with probation well. William Miller. William Miller.
Judge. William Miller was picked up by Roderer this morning. So he is not here. I would request if we could continue this until June.
He was picked up what?
He was picked up by the prison this morning.
It's short motion and Roderer can't be going. It's a short motion.
Yeah, if I'm not wrong, this is the case where Mr. Miller said the reason he absconded was he was in jail all this time in Tennessee. And they were supposed to get me some records that he was in jail in Tennessee during this time, and I've never received anything, so.
We do have some records, but I do not want to have the hearing today. I would like to have it in June when he is present.
All I'm saying is if there's records, I need to see.
Yeah, I'll get them to you.
Okay, well, I'll just continue it generally and you can redocket it.
Yes, Your Honor. Thank you.
Christopher Sutton.
That's your dangerous.
Let me finish this, two more people in the grand jury. Are you Christopher Sutton?
Yes, sir.
Good morning. This is 24 CR 007. Mr. Sutton, were you born in 1995?
Yes, sir.
Last 4 digits, social security number 1321.
Yes.
This is a motion for shock probation. What do you have?
Your Honor, I would like to call Mr. Sutton to testify.
Raise your right hand. Raise your right hand. You swear the testimony you're about to give is the truth, whole truth, and nothing but the truth.
Yes, sir.
Mr. Sutton, can you explain to the court why it is you're asking for shock probation?
I've been in jail. I've been incarcerated for quite some time now, and everything I got was mainly drug charges, and I feel like if I had rehab, honestly, it would give me the tools that I need when I get back
Mainly,
out.
what besides drug charges, what did you have?
They got me with a a step on lawful taking under 1,000 facts. That was their initial charges.
What did you steal?
They said I was taking a tobacco wagon.
Go ahead.
Thank you. Mr. Sutton, were you, previously in the drug court program?
I was.
And can you explain what happened, with that?
I've had dirty urines and they revoked me over.
Okay, how long were you in the drug court program?
Not very long.
Okay, and by not very long, are we talking about days, weeks, months?
Roughly days.
Okay,
That's why I feel like rehab would be a
Yeah.
more reasonable option.
okay, so did, um, are you currently facing a pending circuit case in Barron?
Yes.
Okay, and what is that charge?
Possession card.
What does that stem from? What are the allegations?
Allegations, possessions. I don't know how to know
Okay.
what you mean.
And with regard to, do you have a holder out of Barron Circuit?
Yes.
Okay,
would
is
assume.
it bond?
No, they're just agreeing if I get this, then I can go to rehab also.
Okay. And, do you
What you're
feel,
telling me is why he's been out. He got charged with possession.
yes, Judge, but that was the subject of the underlying revocation we had in this case. He picked up a new possession charge in Barron
that.
that is still pending.
Well, it's in drug court.
Yeah, that is what got,
You had the marijuana, the meth on your person while using the drug court office.
Unknowingly, but yes, what they got me with.
Somebody planted on you
No, sir, I'm assuming that it was left in my clothes, honestly. I
by
didn't
someone
know.
else or?
Who's to say I
Okay,
didn't,
go ahead.
Mr. Sutton, when the incident occurred in drug court, had you been in drug court long enough to have the tools for sobriety?
I hadn't been in drug court long enough to speak with the life skills officer.
Okay, so you had not, gone to any counseling yet?
Nothing.
Okay. You had just started the program pretty much?
Yes.
Okay, I have no further questions.
I don't have any questions.
Your Honor, I would like to make an argument for shock probation on Mr. Sutton's behalf. We would ask the court to grant shock probation, allow Mr. Sutton to go to long-term treatment. When he picked up the possession charge in Barron, he had been in drug court only a matter of days. He had been oriented into the program, but he had not yet been set up for the counseling, which means that while Mr. Sutton was technically in drug court, he had not been given any of the tools or had the opportunity to obtain any of the tools to work on his sobriety. While I understand that, Mr. Sutton does have that pending charge, it is a possession charge. And the best way that we can help Mr. Sutton and ensure no future criminal activity is to send someone to treatment. Drug court did not work out, but we are asking for a long-term treatment. We can arrange the bed. We have, had him assessed while this case has been pending shock probation. He would qualify for treatment. I would provide that bed letter to Mr. Stockton for the Commonwealth to approve of that placement, or if the court would prefer, then we would also be agreeable to probation making the recommendation for treatment. But we are asking the court to give Mr. Sutton one more chance.
Your Honor, the Commonwealth opposes shock probation. Mr. Sutton has a problem with hiding methamphetamine. When he was arrested for stealing the trailer, which is the underlying case in this, he had a 9mm pistol with meth stuck up in the butt of the gun.
Remember.
Now he's got meth in his pocket when he goes into the drug court office. So I just don't see how he would be amenable.
I think Mr. Sutton got a better deal than I thought at the time, you know. because
He served some jail time and then went.
Yeah, you know, I just don't, I just think he just needs to serve his time. Thank you. Michael Vibbert. Michael Vibbert.
Your Honor, he, Rotor is supposed to be bringing him down. We were going to enter a felony plea today on his cases, but we are unable to do so unless and until he gets here. So I would
Once
ask,
you inform me, I'll leave it open. Did
Thank-
y'all clear the jury, you clear the jury box out there. We're gonna bring the grand jury in. As soon as the grand jury finishes their report, we'll go down through the out of custody docket. All rise for the grand jury, please. Okay, everyone can be seated. Who's the foreperson of the grand jury? Mr. Foreman, would you stand up, please? Did 9 or more of you agree on the conclusions you have in your report? Would you present them to the bailiff and let me examine them, please? You have a signature like a movie star. Yeah. Or a doctor. Yeah. Okay, everything seems to be in order, ladies and gentlemen. I'm gonna sign the document that will initiate the process to either have summons issued if these people are already incarcerated or warrants issued if there aren't, with bonds on them that'll be sufficient to assure the protection of the public and their attendance once they come here. That's the purpose of the bond. I want to encourage you to keep anything you heard there confidential, even though you think it might be inconsequential. It could interfere with the case or the apprehension of these individuals and could put witnesses at danger. You will next be called back here on June the 12th. And it's hard for me to believe that this year is going to be over halfway over when you come back, but it just shows. When I was a young man, I heard older people say how quickly time flies by, and I didn't realize how it was, but I'm getting to understand their wisdom now. So thank you for your service here. You may be excused, and let's call back before June the 12th. All rise for the grand jury. Y'all may exit out this way. Okay, everyone have a seat. We're going to go down through this out of custody docket. And then we have several jails or correctional institutions that are scheduled at 10 o'clock. We'll stop the in-person docket for a few minutes and go to those jails, and then we'll resume. Roger Boyd. That was a notice to forfeit. Is there any objection? Roger Boyd.
Your Honor, that's a notice of intent to seek forfeiture. It's a bunch of guns and ammo that needs to be destroyed from that case.
Okay, Mr. Boyd, this was a notice to forfeit for the purpose of destruction of evidence. Do you have any objection to that? Can you hear me, Mr. Boyd?
Yes, sir. I hear you. Can you hear me?
I can hear you. This was,
Okay, no, I don't.
okay, you have any objection? Is Mr. Boyd, can he be excused now? Okay, thank you, Mr. Boyd, for participating. We'll go ahead
All right.
and we'll enter the
Thank you.
order. Yeah. Bryson Coulter. Mr.
That is another notice of intent to seek forfeiture. And for some reason I failed to write that down. It was.
Mr. Johnny Bell is listed as counsel.
Judge, he's still in a nursing home facility. We've contacted, I don't think there's any objection to it.
Okay, we'll enter the order. Thank
Thank
you.
you, Judge.
Teresa Graves. Notice of intent to forfeit.
That is $209.
Okay, we'll enter the order. Herschel Hammer. There's an active warrant out for Herschel Hammer.
He's absconded, but I expect he'll contact probation program and
Devin Howard.
that is also a notice of intent to seek forfeiture. It's $6.
I'll take that under advisement. Okay, I'll go ahead. Taquan Howard.
Your Honor, in that case, last time I was here, the court entered an order for the test.
Let him get up here before we.
Oh, okay, I'm sorry.
Okay, I'll go ahead, Mr. Stockton.
The court entered an order for testing of more of the pills. The new statute on aggravating fentanyl has to be over 28 grams. So the lab is supposed to be conducting more testing. They contacted me after they received the order, but I've not received the new lab report.
So will this continue for you to redock it when
That would be fine.
or you just want to set it out till July 17th?
July 17th, they should have a report.
July
Did I
17th.
check that, Judge? I'm gonna be out of town July. Let me see if I'll be here that day. That's fine, Judge.
July 17th.
Yes, sir.
Okay, that'd be fine. Justin Hunt says active warrant out.
Yes,
Is that correct?
that's correct.
Rita McLaren, the Rocket Docket, okay, Rita McLaren. This is 25 CR 0023. Are you Rita McLaren?
Yes.
You born in 1961?
Yes.
Last four digits of social security number 7140.
Yes.
You hear for the purpose of arraignment. You have a copy of the information for me? Thank you. The docket number has been assigned to this, which is 00023, so I'm going to put that on here. Mrs. McLaren, you appear here on information. It says information indictment, but it's just the information. You determined that you want to go ahead and appear and make your entry appearance. Is that correct? I understand. I'll go ahead and file this over. I understand that you wish to enter a plea today. Is that correct?
Yes.
Is this a felony plea or
It's a pretrial diversion, Your Honor.
diversion? A motion has been tendered that says you wish to enter a guilty plea, which you've acknowledged. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in the information that was numbered 25 CR 0023? Is that you? Same person? Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney? Are you satisfied with her advice?
Yes.
Okay. Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a guilty plea, I need to know that you fully understand those rights. I'm going to go over them with you. The end, if anytime you need to step away from the podium and talk to your attorney, you can. You have a right not to testify against yourself. Nobody can make you say, no one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury or trial, a right to confront and cross-examine all witnesses called to testify against you, right to produce the evidence, right to call witnesses in your favor, have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, a right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges. You understand that by entering this guilty plea, you waive those rights. You understand that? You give up those rights.
Okay.
Yes, sir.
Now, I may consider Commonwealth's recommendation, but I may applying range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation they're about to make and decide to enter a harsher punishment, you can withdraw your plea and go to trial. Do you understand that? Now, I'm going to ask some qualifying questions before the Commonwealth makes their announcement. Have you previously been diverted in the past 5 years?
No,
Do you have any felonies in the past 10 years?
no, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion programs, the charges will be dismissed, pre-trial diverted, and you can have your record expunged. You
Yes, sir.
understand that? But if you do not successfully complete the program, you'll be brought back in, the diversion, rather, you'll be brought back in front of the court, and the court will schedule a sentencing hearing. And then you would be a convicted felon, and that can be used against you in the future. You understand that? Ms. Gordon Anderson, what is the recommendation of the Commonwealth?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, first offense, hydrocodone, the defendant shall receive a sentence of 2 years, pretrial diverted for 4 years, supervised. The defendant shall enter and complete the Monroe County Specialty Court. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agree to, Liam?
Yes.
Okay. Are you pleading guilty because you committed the acts charged in the information?
Pleading guilty because you're guilty of the charge. Yes,
You do so of your own free will.
yes,
Knowing your constitutional rights, it's still your desire to enter the plea and allow me to fix the punishment and the range permitted by law. Is that your signature on the document?
yes.
I'll accept the diversion program. You'll need to meet with probation and parole. Mr. Stockton, was she supposed to get into specialty court?
Yes, yes.
Okay, so she'll meet with probation and parole, give information, and
I'm going to set up with Mr. Graves.
Mr. Graves, you need to make an appointment as soon as you can with Mr. Graves about that, okay? Okay, now I'm going to switch off this live docket for a second and go over to Grayson County. Grayson County, are you on the line? Simpson County Jail, I guess, will be next. If you'll turn your camera off until we get finished, until we call your case, okay? Grayson County Detention Center, Commonwealth of Kentucky.
on, but it's another.
Is Grayson County on there?
No, but it's another.
Okay, it's a forfeiture. There doesn't appear to be anybody appeared to object to it, so I'll enter it. Little Sandy Correctional Complex, are you on the line?
So that'd be Trey Williams will enter the order then, okay?
Yes,
Okay, this is Commonwealth of Kentucky versus Jason Pitcock. Are you Jason Pitcock?
yes, Your Honor.
Pitcock, were you born in 1982?
Yes, Your Honor.
What is it, social security number 2853? Mr.
Yes.
Garrett, you have a motion to present.
I do, Your Honor. Judge, I've got a 6002 motion. Mr. Pitcock pled and was sentenced before the enactment of House Bill 5. But when he was classified at the prison, they classified him as 85%. And it should have been 20%. I've spoken with the Department of Corrections, and they say that a simple order will get that corrected to 20%. And that's what we had negotiated on this case.
Well, that's mostly correct. I know prior to this is the case that was set.
Quite a compliment that you just paid is
Yeah.
mostly correct.
Partially correct. This case was, I think it was last April of 2024. And Mr. Garrett and I attempted to settle the case before trial and we couldn't. We even talked to Mr. Mr. Hogan, who said it would probably be a 20% because of when the date was.
Correct.
And then Mr. Pitcock rejected our offers and was going to go to trial. And we came over here and I didn't come because I had a stomach virus and Miss Gordon Anderson was here and there was a plea negotiated. So whatever plea was that happened, I can't speak to.
Okay, it was the same.
That's what happened.
Yeah, it was the same plea.
What's the Commonwealth's position? You think it's appropriate to make 20%?
Well, I think that was the assumption we were all operating under. But that was the assumption that Mr. Garrett quoted law from the Franklin Circuit Court from Judge Shepherd, but there's not been a Court of Appeals ruling on it yet. But I can't argue against that because that was the assumption we were operating under, was the
So
point.
that's what you agreed to.
Yeah. Basically.
Okay, I'll enter the order.
Thank you, Judge.
You may be excused, Mr. Pitcock.
Thank you.
The Russell County Detention Center. Christopher Caraway. It's another motion of intent to forfeit. There appear to be no one appearing to object to that. You will enter the order. Simpson County Detention Center. Now you can turn your camera on. Commonwealth versus Kayla Spivey. Are you Kayla Spivey?
Yes,
Born in 1992.
yes,
4-digit social security number 9656.
yes.
And Mr. Garrett, what do you have here, Mr.?
Judge, this is basically the same situation where we had negotiated a plea. We had a mediation. I think all the parties agreed that it was a 20% parole eligibility in the negotiation. However, when Frankfurt classified her and the DOC classified her, they entered it as an 85%, which that did not exist for the charges for which she pled at the time they occurred.
What's the Commonwealth?
It's pretty much the same situation, only that we mediated this case. Judge Patton, all our people in our office assumed it would be a 20% case. That's what we informed the family. It's kind of like the old Monopoly game, banker in your favor. You know, I can't agree to it because the family doesn't agree to it. So, but we did operate under that assumption that it was 20%.
What she entered?
She entered a plea to to facilitation of murders with the, actually.
I'm gonna take this one under advisement.
Okay, and Judge, I wanted to add.
I'll take it under advisement. I'm not gonna sign it today. We'll just see how what the appellate court says before I make a determination. Okay?
Okay.
Thank you. Your attorney will be in contact with you, Ms. Spivey. Now, Barron County is not supposed to come on till 10:30, so I'm gonna go back to the live docket. Next one up is Heather Payne. Heather Payne for arraignment. Commonwealth versus Heather Payne, 25 CR 0020. Are you Heather Payne? Were you born in 1971?
Yes, sir.
Last 4 digits, social security number 4558.
Correct.
You're represented by the Office of Public Advocacy. You have a right to remain silent. The grand jury of Monroe County has charged you with possession of controlled substance, first degree methamphetamine, and possession of drug paraphernalia. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order here that require the Commonwealth to provide you the information to prepare for your defense. You'll be here at 9 o'clock on June the 6th for negotiations, and your next court date is on June the 12th, okay? Commonwealth versus Robles. (24 CR 00015). Mr. Robles is here. Is coming up the I'll hear. This is a motion to secure attendance of a witness file with Mr. Gary. What do you have to say, Mr. Gary?
It would have been,
No, it's just for the last witnesses.
yeah, I didn't follow it.
No, it's my motion, Your Honor. You want to know, I guess if you objected to it or not.
No. I don't think I have grounds.
So we can enter the order to secure the presence of an out-of-state witness. Do we have any dates set in this?
August 27th, trial day.
August 27th? Is there any reason to have another pretrial?
Mr. Garrett, I'll be filing one motion and limiting. I'll probably try to get that filed for next month.
Okay, thank you. You may go. Jonathan Russell, that's another intent to forfeit. Mr. Bell,
Since we've gotten hold of Mr. Russell, there was some items that the court had signed in order for him to get returned. They advised us he needs to come and get that stuff. We've advised him of that, but anything outside of that, there's no objection.
enter an order, give him 30 days from today to pick up anything that he wants to claim, or it'll be forfeited also, okay?
Thank you, Judge.
Okay. Tanisha,
Can I clarify, Your Honor, before we move on? The Commonwealth's motion is to forfeit guns, magazines, and he's not entitled to that anyway, so there's no objection to that, is there?
no, I meant to enter the order to forfeit those. He said there, if there was other personality,
Yeah, the iPhones, then if he wants to have 30 days to pick those up.
but
I don't know. I know we listed a Ruger.
Yeah.
Bolt action hunting rifle.
Whatever's in the whatever's in the court order, Judge, and it's signed by Your Honor, is fine with me. Anything outside.
well, thank you, thank you.
It's the matter.
Yeah, but you've expressed a better attitude than most defense counsel.
Well, I'll ask to enter the order on the guns and then we'll enter an order giving him 30 days to pick up his phone.
That'll be fine.
Wait, you got that.
Did I call Tanisha Shirley? No, forfeiture.
She's on Zoom.
Hello, Miss Shirley.
Hey.
Yeah, what is this? This is a motion of forfeiture destruction. What do you have, Mr. Stockton?
It's well, I thought I had it written down. Find it. It is to forfeit $1,869 that was seized at the time of the arrest.
Was that in the agreement?
No, it was not. That's the reason I've come back and filed all these motions, Your Honor, to try to clean out the evidence.
There's a crowd.
She wasn't tried, was she?
Her.
Oh, okay.
Yeah.
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 Are you representing Brad Gordon represented you? Is that correct at trial?
Yes, Your Honor.
Where are you today?
I'm in Louisville. I'm getting ready for work.
Well, if she objects, I guess we can have a hearing. If not, we can enter it over.
Do you object to the forfeiture of the money?
No, sir.
Okay, well, we'll enter an order. I hope you have a nice day. Thank you very much.
Thank you.
Kyle Simmons,
No.
Commonwealth versus Kyle Simmons, 24 CR 0053. For review, it says, Mr. Simmons, were you born in 1990?
Yes, sir.
Last four digits, social security number 8515.
Yes, sir.
What do you have, Mr. Stockton?
You know, when I filed this motion, Mr. Simmons had some medical issues. I think he's on the track to getting those taken care of and getting treatment. Mr. Collins says he's not had any problems with him since he's been under that treatment, so I'm asking to withdraw my motion to revoke.
You may go forth rejoicing. You may leave, okay?
Thank you.
Angela Smith, motion for intent to forfeit.
That's $799.
There's nobody appearing to object here. I enter the order. Damian Tackett, active warrant. Benjamin Tooley, sentencing.
He's in custody, Brandon.
Okay, well, we'll see when we get to the Barron County docket at 10:30. We'll see if we can have him pulled up, okay?
Yes, sir.
Have you gone over the pre-sentence investigation report with him?
We have to.
Okay. Guy Williams,
Judge Guy Williams, my client, and we have some information here from the Monroe County Family Practice. He had another stomach surgery, it's his second one, and just basically asked the court if they would excuse him from court today due to abdominal surgery.
when did he have the surgery?
He's had two, Judge. I think he just got out of the hospital yesterday or the day before. Says he has drainal tubes, having a lot of abdominal pain. Can't sit upright for any period of long
What's he
period.
charged with?
Possession. Yeah, 2.5 grams of mail. No insurance. I think he's not gonna be driving while he's out.
He ain't able to drive.
That's what I'm saying. I
Yeah,
think
no, he's not
gonna be driving.
capable.
June the 12th.
Yes.
Sky Williams, notice of intent. What? Good morning, Mr. Williams.
Good morning.
This is a notice of intent to forfeit or destruction. Mr. Stockton, what do you want to come up here?
$281.15 here. What we're asking.
Just a forfeiture, $281. You have any objection to that?
No, sir.
Okay, thank you very much.
Thank
you. Hope you're doing well. See you.
See you.
Okay, that finishes the out of custody docket. And it's now time, we're still a little early for Barron County. I guess we had an evidentiary hearing in John Smith case scheduled for 11. So let's go off the record here for a minute till it becomes 10:30. I guess we can make Barron County aware that we need to have Benjamin Tooley. Let me go on there, so. Let's go to the Barron County Correctional Institute or Detention Center. Barron County, we have, you have someone else that I want you to have ready. Benjamin Tooley, we need to add to your list of people that we need to see today, okay?
I've already informed him.
Okay, have you already informed him? Okay. A day late and a dollar short, that's me. Commonwealth versus Mike Austin. Michael Austin. Commonwealth versus Michael Austin. Are you Michael Austin?
They're muted, Judge.
Y'all need to turn your microphone on. Mr. Bell can read lips, but the rest of us are having trouble.
I can't even see
Turn that
it.
microphone on. There you go. Commonwealth versus Michael Austin. 21 CR 0078 and 25 CR 0015. Are you our Michael Austin?
Yes, sir.
Born in 1966.
Yes, sir.
Last four digits, social security 7734. Now in 21 CR 78, we're on a probation revocation, and the other one is a pretrial conference. What do we have in this case here?
Your Honor, I would ask for one more pretrial conference. Mr. Vale furnished me voluminous medical records history, and I've not had time to go through them.
Voluminous.
Voluminous.
I
As in
think that
4
means
inches
a lot,
thick.
Judge. I'm not sorry.
Several.
Yeah.
Okay, when do you want to do this?
Negotiations June 6th at 9, and then the next motion date.
June 6th and June 12th. June 6th for negotiation, June 12th. Your lawyer will be over to talk to you about it, Mr. Austin, okay?
Yes, sir.
David Buck. Commonwealth, David Buck.
Yes, sir.
This is 24 CR 0080 and 24 CR 0078. Mr. Buck was born in 1954 and last four digits, social security number 4580. What's the Commonwealth had to say?
Your Honor, this started out as my motion for supervised visitation, probation, I'm sorry. After he was released from the Monroe County with a drug court, he was administratively discharged. He's got a 5-year sentence. And you wanted him to get housing, DPA to get housing for him. I don't think they've been able to. Is that right?
No, we are Mr. Buck wishes to stand revoked, Your Honor, on both of the cases after further communication with him.
He wishes to do what?
He wishes to stand revoked on these and would like to get his time calculated by DOC.
Okay, we can accomplish that.
I believe it's a pretrial department.
So I'll have to
Is it?
order a pre-sentence investigation report to be done by probation and parole. We'll have a sentencing on the 12th. And Mr. Buck, this time will be good that you're getting it towards your calculation, okay?
Thank you.
James Dockery. James Dockery. Commonwealth versus James Dockery, 25 CR 006 for sentencing. You are James Dockery, is that correct?
Yes.
Born in 1963.
Yes, sir.
Last four digits of your social security number 6386. Mr. Dockery, have you had an opportunity to look at the pre-sentence investigation? Probation and parole?
Yes.
Substantially correct.
Yes.
Counsel, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to failure to comply with sex offender register first offense, the defendant shows of 1 year served. Okay, thank you very much. Mark Hunter.
Yes, sir.
Commonwealth versus Mark Hunter. 19 CR 00114 and 22 CR 0053. Mr. Hunter, were you born in 1977?
Yes, sir.
Last four digits of your social security number, 8597.
Yes, sir.
Okay, we're here on a shock probation revocation. What's the Commonwealth have to say?
Your Honor, he has a 6-year sentence, 2 cases registered. And I would need Mr. Hogan to testify. We are wanting this repassed.
We were wanting this one. Yes. Your Honor, if we could pass this until next month's rule day. The motion for this was filed last Friday. I was out of the office and due to schedule this week leading up to this court docket, I have not been able to prepare for this
You have no
revocation
objection.
proceeding.
Schedule it for June the 12th.
Thank you, Your Honor.
Your attorney has requested time to help prepare for the hearing. So we'll see you on June the 12th, Mr. Hunter.
All right. Thank you, sir.
Leslie Jenkins. Leslie Jenkins. Good morning.
Morning.
20 CR 0041, 21 CR 0049. You were born in 1982, is that correct?
Yes, sir.
Last four digits social security number is 0565.
Yes, sir.
Mr. Stockton, it's a probation revocation. What do you have?
She has a 4-year sentence, 2 counts.
Would you move over behind the microphone? I'm having a little trouble. I'm sorry.
And Taylor Barton will be our witness. I believe we have the same request in this case, Your Honor.
Yes, Your Honor. We would request if we could pass this for a June date. Ms. Jenkins was picked up on her bench warrant. We have not had the,
June 12th.
thank you.
Ms. Barton this is going to be continued to June 12th because of the short notice of service on the defendant. If you'll be available that day, we'd appreciate it, okay?
Yes, Your Honor. Thank you.
Thank you very much. Jose Robles. This is another motion to secure the attendance of a witness. You have no
No
objection?
objection. I don't think we have standing objection.
Okay, well. Michael Turner for review. Commonwealth versus Michael Turner. 0055. Mr. Turner was born in 1967. The last four digits for social security number 1161 is for review. Was a Commonwealth.
Your Honor, the Commonwealth and District Court has filed a petition for involuntary hospitalization. I also contacted Mr. Stevens, the county attorney, yesterday and asked him to file a petition for guardianship where the state could be appointed guardians for Mr. Turner. I would just let the case continue till both of those matters are accomplished.
Since he's incarcerated, let's give a date certain. Let's put June the 12th to review this again. Your attorney.
Say something.
Your earning.
I'm not talking. He's not coming to see me. I'm not talking to my attorney. And I was released 3 times.
Wait just a second. Wait just a second.
Charges filed against him.
Wait just a second.
For saying me against the door last time.
Sir, I'm telling you to be quiet. I'm trying to help you here just for a second, okay? When have you been over to see him?
It's been a few months, Judge, I think.
Well, you need to go over and consult with this gentleman within this week, within a week from today. Your attorney will be over to see you. I've ordered him to come over and see you and discuss this matter with you, Mr. Turner, okay?
Can I say something, Your Honor?
At your own peril. You know, anything you say could be used against you, but go ahead.
I don't need no guardian. They're trying to commit me for property and everything. I'm an eyewitness to them killing Katie Cawthorn. I have tried to get the state police and the FBI in here, and they have robbed me blind out there, even tore my house down. Stole my truck, and I can't get nothing done.
Okay, I can't talk about the case with you here, okay? Your attorney will be over to talk to you, and he'll explain what your options are, okay? Thank you very much.
Well, he's working for them. Can I fire him and be let out?
Okay, take the gentleman back to his cell.
Don't touch me.
Thank you very much. Oh, it's a pleasure talking to you. Brittany Williams. Brittany Williams.
Yes, sir.
Commonwealth versus Brittany Williams, 25 CR 0021. Are you Brittany Williams?
Yes, sir.
Were you born in 1991?
Yes, sir.
Last four digits of your social security number 2941. You're here for the purpose of arraignment.
Yes, sir.
Did the public advocate's office represent you in district court?
No, I never went to court. They just took it all upstairs.
Okay, I'll go ahead and get an affidavit here.
Okay.
I'm going ahead and appoint public advocacy to represent you and then ask you to, we got an affidavit on? Okay, you look like you're qualified, so I'll go ahead and sign public advocacy. You have the right to remain silent. Your attorney, if you need to speak to your attorney, I can have you arrange where you talk to your attorney even during this arraignment. Grand jury of Monroe County has returned an indictment charging you with possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia, some marijuana. Do you understand those charges?
Yes, sir.
Okay. I'm signing thank you. I'm signing a reciprocal discovery order. It requires the Commonwealth to give you the information that they have to help you prepare for the defense. You will be here on June the 6th at 9 a.m. For negotiation, and June the 12th at 9 a.m. for your next appearance. What kind of bond is this lady? 15,000. Do you have anybody to come sign your bond, ma'am? It's just a $15,000 surety bond. They don't have to put any money up or anything.
Yeah, I can get somebody to come sign it, yeah.
Well, that's what your bond is. If they come to the jail over there and sign the bond, or they can come in here to the circuit clerk's office in Monroe County, probably better. Yeah, it's clerk approved surety. So have somebody come here and just and answer the questions to assure the clerk that they're worth 15,000, and they can sign your bond. And those are the two dates I gave you, the 6th and the 12th to be back. Okay.
Okay.
David Wood. David Wood. Are you David Wood?
Yes, Your Honor.
Morning. This is 25 CR 0017. Were you born in 1981?
Yes, Your Honor.
Last four digits, social security number 2810.
Yes.
Represented by Mr. Garrett here on this pretrial conference. What do you have to say?
This is a possession case. This is for pretrial. Mr. Wood is a state prisoner, but he has a parole date in June the 1st. I would like to have a negotiation June 6th and the 12th so we can see what the parole board does. So we'll know how to
So
handle
they're gonna wait. Will this, Mr. Stockton, will this be pending affect what the parole board does?
Yes, I'll have a position depending on whether he's paroled out on how to handle this.
I know, but I'm asking if the parole board will be influenced by the fact that he's got a pending charge. What do you think?
I think they could.
What's he in for now?
Possession.
Now, I thought it's 5 years on something else.
Yeah, it's a D, I think.
It's a defense. I still want to change it or something. So I'll give him a year to serve if he wants to plead to that today, do consecutive, otherwise I can wait.
We want to wait, Judge, to.
Okay, we'll come back here on June the 12th. They want to see what the parole board does, sir. And okay, thank you very much. Okay, now let's go back and get Benjamin Tooley. Benjamin Tooley. Commonwealth versus Benjamin Tooley. (24 CR 0020). Are you Benjamin Tooley?
Yes, sir.
Good morning. You born in 1987. Last
sir.
social security number 2174. You're here for sentence. You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Substantially correct,
Yes.
Mr. That's the way I was going. I don't know what I called the right number. Did I call 24CR0020? Yeah, okay. Mr. Bell, if you had an opportunity to look at this, is there any reason this defendant should not be sentenced?
There is not, Your Honor. The only issue we had, and we've talked to probation pros about the days he was given.
On a plea of guilty to possession of controlled substance, first degree, first offense, the defendant shall receive a sentence of 1 year. And the ballot's probated for 5 years. It's still run consecutively to Monroe indictment 20CR005, 21CR0093, and 21CR0092. What is the problem? Are you still working on the number of days?
Right, maybe I have to explain what's going on.
It's always
So-
good.
He's got to serve his 120 days before goes to rehab. He's only been credited 24 days. Because he was held on a probation violation on a lot of the time he's been in jail on a previous case. He only got time from the time he was arrested on 2/20 till he made bond on 3/14.
That would be correct.
But he's never been out since that time. We were hoping you would give him credit for the time of his arrest.
I don't think that was the intent of the plea. Is that correct, Mr. Stockton?
I think Mr. Toohey's getting a good break. I hope he does well after he gets his time in and goes to rehab.
Okay, thank you very much.
Thank you, Judge. You have a good day.
Thank you. Is there anyone else? Court call, I'm gonna waive the court costs on Mr. Tooley since the time he served.
Thank you.
Okay, now we have an evidentiary hearing, is that correct?
You do, Your Honor, but one matter before that, if we could take up Kendra Ford, who was not on the docket, 20CR77. We've submitted an order to extend her probation. She's graduating from the special report program, but her probation expires about 2 days before the
Is
graduation.
her here?
She is here, Your Honor.
So we're just asking to extend her probation for 90 days.
You gonna be a graduate?
Yeah.
Okay, well, that's good. Well,
Thank
we'll extend, under agreement, we'll extend your probationary period, okay?
Thank you.
Thank you very much. Congratulations.
Thank you so much.
Okay.
Judge, we still have two more matters. One is Michael Vivert.
Is it on the docket?
He was on the docket. This is the one that we believe that that the prison was bringing down. They have not transported. We would request that to be placed on the June docket. We believe we can put the,
Have no
Get
problem
to
with
play
that.
it
What's
that
your other?
the other one is, an order if you, on Miss Tamara Stamper. We had done an agreed order that you had signed, but you had not signed the order for her to be evaluated.
Do you have any objection to this? Mr. Stockton?
No, Your Honor. Well, that was.
Okay,
Thank you, Your Honor.
Thank you. Okay, we have the matter of Commonwealth versus John Wood. 12CR0041-001, an evidentiary hearing. Call that case. John Smith, yes. Who's handling the evidentiary hearing for the Commonwealth?
Mr. Hunley and he stepped to the restroom.
Is John Smith here?
Yes.
Yeah, this should work for the correction doc.
For John Smith.
You get it on record anymore that you asked for extension and they denied it. I think so. I know that I said that. I done wrestling about it. She's like, she doesn't think that's a paper. The only person I did was wrestling.
Y'all are picking up on the microphone over there. One person.
Who would that be, Judge?
The voice sounds vaguely familiar. Okay, we're here on, for a hearing on 1142 motion in which the Court of Appeals ordered us to take evidence in the form of an evidentiary hearing on the issue of ineffective assistance of counsel as it relates to trial counsels not introducing evidence of Mr. Smith's alibi. Is that correct statement, counsel?
Yes.
Okay. You want to call your
I don't believe the burden is on the Commonwealth on this, Your Honor.
He's correct. It's our burden.
Well, you want to call somebody or we at?
I would call Mr. Smith.
Impasse.
I'll call Mr. Smith.
Hey, Mr. Smith, come up and take the stand, Mr. Smith. Show Mr. Smith where to go here, Mr. Bailiff. Thank you. Okay, Mr. Smith, the best you can, will you raise your right hand? You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
Have a seat there and state your name and answer your counsel's question.
John Smith.
Okay, counsel, you may proceed.
Thank you. Mr. Smith, you know that we're here today on an 1142 motion that you filed regarding your conviction that occurred in this court previously.
Yes, ma'am.
Okay. And the subject of this hearing, just to kind of get us oriented, as we have discussed, the Court of Appeals has allowed us to present evidence on the issue of whether, about your alibi defense. Is
Yes,
that
ma'am.
correct? Okay. Can you tell the court, explain to us what that alibi defense was?
Well, the state police took a cell phone off of me and it had several messages on it where I called Chastity Hagan from Wanda Hagan's home phone. It was a landline. And nobody ever seemed to care to try to get them messages or see that the calls was made. You can't be in two places at once.
Had you also made, now we are talking about, just to make sure that we're all on the same page, we're talking about the time frame in which the murder that you were convicted of occurred.
Yes, ma'am.
Correct? Okay. So during that time period, where were you?
I was at Chastity Hagan's mama's house.
And did you make phone calls from the landline there at that residence?
Yes, ma'am.
Who did you make phone calls to?
I called Chastity on her cell phone.
Did you also call someone named Loretta?
Loretta Deckard, yes.
Okay. And it was your belief that this would prove where you were during that time, correct?
Yes, ma'am.
Did you advise your attorneys of this?
Yes, ma'am.
Who did you tell?
Well, Miss Sandra Downs and Mr. Michael Buffkin.
And were they the attorneys representing you at that time?
Yes, ma'am.
And what kind of response did you get from them regarding that?
They act like it'd been looked at, but it couldn't have been looked at or they would have known the times and everything I'm talking about.
Did they talk to you about any efforts they had made to, as you say, look into that?
Not that I know of.
Did you ever speak to any investigators in the case?
Yes,
That were working for the defense, not like police?
yes.
Okay. Do you remember who those people were?
One of them was Josephine Guy and the other one was, Miss Jessica Shoemaker.
And did you talk to them about this issue as well?
Yes, I did.
And what kind of response did they give?
Apparently they never checked on it because the proof's there.
Now, you actually proceeded to a jury trial in this matter, right?
Yes, ma'am.
At that trial, were there any witnesses called to present this defense that you're talking about?
No,
So no one testified regarding any kind of phone records from the house that you say you were at?
no, ma'am.
And there were no witnesses called who said that they had had a conversation with you during that time?
No, ma'am.
Were you able to speak to your attorneys about why that was?
Kind of after my trial, I never had much contact with them after that.
So you never did have an explanation?
No.
Is there anything else about this issue, as you know?
Did he say after the trial?
Yes.
Yeah.
That's correct, right? You
Yes,
said
ma'am.
after the trial. Is there anything else as regards to this particular issue that you would like the court to know?
It's like somebody check into them phone records because you can't be in two places at once.
And it is your contention that you were at that home and did not commit this murder?
Yes, ma'am, that's a fact.
I have nothing further from Mr. Smith at this time.
Commonwealth have any questions?
A moment, Your Honor. Mr. Smith, you remember in the hours following Miss Howard's death, you were taken into custody by police officers.
State police, yes.
Did you tell them about these phone calls?
They's the one who took the phone off of me. I had the phone on me at that time.
No, my question was, did you tell the officers about these phone calls?
I was too busy getting kicked to the ground and handcuffed.
So I take it your answer is no, you didn't tell them?
I told the detectives when they questioned me, I think his name was, Russell Deckard and,
Officer Brooks?
Barry Brooks. No, it wasn't Barry Brooks. He was a Brooks, so.
Did you tell those officers then
Oh.
that you had an alibi or the possibility of an alibi?
I've told everybody I've ever talked to about it.
Yeah, my question is, did
Yes,
you
sir.
tell those officers about
Yes, sir.
that? Where did that conversation or that interrogation take place?
The city police hall.
All right. About how long was it?
Couple hours, I'd say, hour and a half, 2 hours.
Or they were accusing you of the murder of Mrs. Howard, weren't they?
Yes,
And you denied it.
yes.
But you didn't tell them specifically about this alibi?
I've told everyone I've ever talked to.
But did you
everyone.
tell these two officers, now,
Yes,
wait
sir.
a minute.
Wait till he finishes his question before you answer, okay? Go ahead, Mr.
If I were being interrogated for a murder that happened less than 24 hours before that, and I had an alibi that would prove I was somewhere else, don't you believe I would tell those officers that then and not here 10 years later?
I told them then, I'm telling them now. I've told anybody to listen to me.
So that's your testimony. You told the officer.
I've told everyone that's ever listened to me.
Was that at the place
The
that?
officers,
Wait. Let him finish it, Mr. Huntley. Let him, you go ahead and finish.
I've told the officers, I've told every lawyer I've had 15 different lawyers. I've told everyone that's ever been around me that's been involved in this case.
Describing the scenario I just gave you, don't you believe if I had an alibi, I would tell the officers then?
I told them then.
Ask and answer it. He said he did tell him.
I did tell them then. I've told every lawyer I've had.
Move on.
I have nothing further.
I have a question. Did you mention it to your lawyers at the trial? I mean, you said you talked to them after the trial. You were at the trial.
Yes, sir.
You didn't mention it at the trial to them?
I mentioned everything to Mr. Buffkin over
I'm
here.
asking you specifically. Did you
Yes.
mention at the trial that you thought that they ought to call the alibi, to challenge the alibi?
I've told him a dozen times, even at my trial.
Thank
He
you.
asked me, what do you think I need to ask? I'm not an attorney. I told him about my alibi, because that proves everything I'm saying.
Thank you very much. Now, do you have another witness?
Can I do redirect just
You
very?
surely may.
Just to be clear, your testimony on direct was that you had told your attorneys before the trial, during preparation.
Yes, way before the trial.
That wasn't his testimony, I don't believe, but now I'll
I
accept
believe
it.
it was.
Well, I'll accept it now. That's what he's testified to.
And I think what you said was that you didn't get to speak to them after the trial.
After the trial.
Okay. And I also just wanted to clarify, because you also mentioned to Mr. Hunley, that a phone was taken from you.
Yes, ma'am.
I think that could be a little unclear, so explain to the court whose cell phone you're talking about that was taken from your person.
It was Chastity's phone. It was a cell phone.
Okay, so during the time frame that we're talking about, the alibi defense, did you have the cell phone at that time?
I had the cell phone when the state police arrested me.
So you didn't have it during
No.
the time, okay?
No, ma'am. I
Who
called from,
did have it?
Chastity had it.
Okay, so when you say that cell phone
Yes,
would show that you made calls, it would show that you made calls from the landline
Yes, ma'am.
to Chastity.
yes, ma'am.
I just wanted to make sure that that was clear. I think that's all.
Mr. Huntley.
Do I understand that night or the next morning, you did not have Chastity's telephone?
I had it that morning when the police arrested me. I had the cell phone in my pocket.
Did you tell the state police that you didn't make any phone calls on that phone? You didn't?
I didn't make no calls on it. I made them to it.
Did you not tell the state police that you didn't make any phone calls while you were at Wanda's?
The two
Judge,
state,
I'm a little confused by that question myself. There were a lot of negatives in there.
Yeah, just restated.
Did you tell the state police that you did not make any telephone calls that night when you say you were at Wanda's?
no, I didn't tell them I hadn't made no phone calls because I had.
Did they question you about whether you had made phone calls?
Mr. Brooks and Mr. Decker, when they questioned me, I told them about the cell phone. Nobody has ever wanted to check into it. I've never seen nothing that shows nobody's ever checked into that. My lawyers, no detectives, nobody.
Did they talk to you about cell towers and the ability they had to track people using cell phones?
That's what I want to do. Yes.
You all discussed, they discussed that with you that night.
I told them about the phones. Before I made the call and left the
My question
messages.
is, that next morning, when they had you in custody and they were interrogating you, they were interrogating you about the use of the phones and how they had the ability to track them. Is that correct?
I mean, I know they have the ability to track them because that's what I wanted to do.
And didn't you tell them that you didn't make any calls that night or that morning?
No, sir, I didn't tell them I hadn't made no phone calls because I had made phone calls.
All right.
Do you have anything else, Counselor?
Not for Mr. Smith, no.
Okay, you can stand down.
Your Honor, please.
You have another witness?
I have.
Wait a sec, wait a sec.
All right.
I do. I filed a motion yesterday. I e-filed a motion in writing rather than just waiting to do it verbally to allow a witness to testify remotely today. It's Jessica Shoemaker, who was previously an investigator with the Department of Public Advocacy. She is no longer employed by DPA and she lives out of state now. She is available to testify either by Zoom or by telephone.
What do y'all have to say about that?
I would think that would be the ruling for the court, John.
I know, but I want to hear what you have to say about it.
Well, I'm not particularly happy about it.
Okay. Well, is she online now?
I can get her on, she's waiting by her phone for me
Can you give
to,
her a Zoom link?
I can give her a Zoom link if the court gives it to me.
Come up here. Get the Zoom link.
I will get an email address.
You got your CD, can
We don't have more times a civil. We have a civil document. No, I get it. We have a civil document. What things? Do we have anything else this morning? Yeah, anybody here for sure? Still. Let's go off the record.
They want to one of them.
Is this lady an attorney?
She is an investigator. She's a private investigator now. She was previously employed by the Department of Public
She
Advocacy.
wasn't employed as an attorney.
No, she's
She's an investigator.
she's an investigator. There, she's on there now.
Okay.
Is it best for me to stay here to do questioning of her, or is there somewhere else I
I'd
should
say it
go?
would be better he came to the podium. You want to call your next witness, please?
Thank you, Judge. I called Jessica Shoemaker.
Are you Jessica Shoemaker?
Yes, sir.
Raise your right hand, please. Swear the testimony that gives the truth, the whole truth, and nothing but the truth.
Yes, sir.
What's your name?
Jessica Shoemaker.
May proceed.
Thank you. Ms. Shoemaker, can you tell us where you're employed now?
Yes, I am employed with Inquisitor Inc., investigation firm out of Memphis, Tennessee.
Okay, and what do you do for them?
I am criminal defense investigator. I do fact investigation and mitigation investigation.
Okay, and we are here today on the case of Commonwealth versus John Smith. And you have some knowledge about that case, is that correct?
Yes.
How did you come to have knowledge about that case? What has your involvement been?
When this case was going on, the trial, I worked for the Capital Trial Branch of the Department of Public Advocacy in Kentucky. And one of the attorneys there was Mike Buffkin, and he brought me in to help with the case when funding ran out for the Chapter 31 fact investigator.
Okay, so there had previously been an outside of the agency investigator who was working on the case?
Yes.
And do you recall who that was?
Josephine, I can't remember her last name.
Josephine Guy, does that sound?
Yes, Josephine Guy, yes.
And you said that funding ran out for her. Can you explain that just a little bit?
I'll be honest with you, I don't know that much about it other than for whatever reason she couldn't continue to work because she didn't have funding. And so my boss at the time was Joanne Lynch, and she asked me to help Mike with the case to finish up subpoenas and things like that, last minute things that needed to be done.
Okay. So as part of your work on the case, were you told by anyone involved in the case about a potential alibi defense that Mr. Smith had?
Objection to anyone, Your Honor.
Okay. Were you told that there was a potential alibi defense?
By saying objection.
I overrule. If she was told by anyone, she needs to state their name. What? Could you name any person that gave you any information concerning the lack of an alibi defense?
So I'll be honest with you that I don't remember exactly who told me. No,
wait, no.
Okay.
Okay. As part of your duties on this case, did you investigate a potential alibi defense?
Yes. I was asked to interview Loretta Walker.
And what was the substance what were you trying to find out from Miss Walker?
Well, when I interviewed her, um, I was asking her about phone calls that she made, with John Smith, at the time of the offense.
Okay,
I object to this as hearsay, Your Honor.
Judge, it's not offered for the truth of the matter asserted. Ms. Shoemaker is testifying about actions that she took during her work on the case.
Who did she say that to her? Who told,
Ms. Walker, Loretta Walker,
where is Loretta Walker? Is she gonna testify?
she is not. But again, this is not offered for the truth of the matter asserted of any of the statements of Ms. Walker. This is simply offered to show that Ms. Shoemaker conducted investigation into this issue.
Go ahead.
Ms. Shoemaker, did you, as the investigator assigned to work on the case, did you believe that there,
Her beliefs, Your Honor.
if I could finish the question and then maybe you can object to it.
Let her finish the question.
Did you believe that Ms. Walker had relevant testimony?
Yes.
Did you at any time make any effort to secure Ms. Walker's testimony in court?
Yes. The first time that I interviewed her, I served her with the subpoena because I believed that her testimony would be relevant to the case.
Okay.
When the trial date changed, I gave her a new subpoena for the correct trial date so that she would come to testify during the trial.
And did Ms. Walker appear in court?
No.
Are you aware of any efforts that were made to, any further efforts that were made to secure Ms. Walker's testimony?
No.
Were you asked to go find her or do anything else to get her to court?
No.
I have nothing further, Ms. Shoemaker. I believe that the Commonwealth will likely have questions for you. Thank you.
Give us a moment, Your Honor.
You may have a moment.
Ms. Shoemaker, did you file any kind of written reports to anyone on your efforts with Loretta Walker?
I gave them to the attorneys. The defense attorneys that I was working for, I gave them a memo about my interactions with her.
Do you maintain those records yourself?
Yes, sir. When I left the public defender's office, I saved a copy of those files. So I have a copy of it.
But we don't have it here today.
No, sir.
Have you made it available to Ms. Lewis?
Yes, I emailed her a copy of my memo.
Did you make any effort to find Loretta Walker and bring her in?
Not the day of the trial, that I can recall. I'll put it that way.
Well, put it in another way. When did you make any effort to bring her in?
Well, when I served her with subpoenas, those were my efforts to bring her in. And my understanding was that that would require her to be in court. And so on the day that she didn't appear, I assumed that she would be ordered to come in by the court, but as far as I know, that didn't happen.
Do you recall if you filed with the clerk proof of service of these subpoenas?
I do not recall.
Thank you.
I have nothing further.
May this witness be excused? You
Yes.
may be excused. Thank you for your attendance.
Thank you.
Thank you, Ms. Shoemaker.
Thank you.
You have another witness,
I would call Attorney Mike Buffkin.
Mr. Buffkin? You raise your right hand, you swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do so, Your Honor.
Take a seat there and state your name.
Can you state your name for the record?
Yes, my name is Michael Joseph Buffkin.
And Mr. Buffkin, what was your involvement in the case against Mr. Smith?
I was one of the defense attorneys.
And were you employed privately by Mr. Smith or by the Department of Public Advocacy?
I was employed by the Department of Public Advocacy.
Were there other people on your team?
Yes, an attorney, Sandra Downs. Jessica Shoemaker was an investigator. Another investigator was Josephine Guy. And then, of course, we had support staff who I don't really remember their names, but there were people who also helped out with the case.
And I'm sure, Mr. Buffkin, that this is a voluminous case. It was a multi-day
Right.
trial, but we're limited to one issue. So,
Yes, ma'am.
And that you've heard that issue is the potential alibi defense.
That's my understanding, yes.
Do you recall being informed of a potential alibi defense?
I'm not honestly sure. However, I know that a Loretta Decker, and I thought her last name was Wallace, but I could be mistaken about it, but that Loretta Decker was subpoenaed to be brought in. I also know that I made an investigative request to Joe Guy to contact Loretta Decker and get a statement from her. And I presume I was asking her to follow up on what Mr. Smith had told us.
Do you, if you remember, because I know it's been a while, do you remember if you intended for Ms. Walker to testify?
I would not have issued a subpoena if I had not intended to call her as a witness. I may have subpoenaed her as a standby witness. I've done that before, where I've called somebody in, but then found either that I didn't think it was necessary to call them, or I determined somehow that it wasn't good to call them, but, for a variety of reasons. But the whole purpose of the subpoena was to bring her in.
And would Ms. Shoemaker or any other investigator working for you, would they have issued a subpoena that you didn't tell them to do?
No, I think they would have done exactly what I asked them to do.
So if a subpoena was issued, it was at your direction or another attorney?
That's correct. That's correct. It would be either myself or Ms. Downs. Subpoenas have the attorney's names on it, so ones that I had issued would have my name on them, and others might have had Sandra Downs' name on them.
Now, in general, if you subpoena a witness to court and they don't appear, do you have any recourse there? Is there any
Yes.
What would that generally be?
Ask the judge to send sheriffs out to get them.
Do you recall if that happened with Miss Decker or Miss Walker? I have Loretta Decker Walker is the name I have.
In all honesty, I don't know if that was done or not, but I know that anytime I've ever had a subpoenaed witness for an evidentiary hearing or a trial and they didn't show up and I wanted them there, I would have told the judge and requested that the judge get the sheriffs to go see if they could find them. That's been my practice for a very, very long time.
Do you recall making a decision that you did not want Miss Walker to testify?
No, I don't recall making that decision.
Do you recall if you at some point decided that her testimony was not needed?
That's difficult for me to answer because honestly, I'd have to go thoroughly through the file, but I can tell you a little bit about what I did in that kind of, in regards to that.
Okay.
We subpoenaed cell phone records. We subpoenaed landline records. And if we had a particular time that we were trying to pinpoint, we would cross-reference that with the different records that we would have. In addition, there's a process of what's known as triangulation. But that usually involves anywhere from 3 to 4 cell towers in which the radio signals are bouncing off towers. Sometimes a cell phone radio wave will bounce off one tower and then the person goes a mile and bounces off a different tower. So it gets to be a little hairy, I would say, with cell phones to determine location. It's not like a landline where a landline has a physical address attached to it, and that's where it is. That's where it always has been, unless the phone company takes it out. So it's a little more dicey when it comes to cell phones. But yeah, there is a process, and I'm not a scientist, so I don't think I can exactly explain exactly how it works, but I think it has to do with the radio waves intersecting and being able to determine where that location is. So, and then of course, times, you look for time stamps as to when those calls may have occurred, because if it was a phone call from last month, it might not have any relevance at all.
And you heard Mr. Smith's testimony that he testified he was at a physical home and made calls from a landline
Right.
during the time period in question. Do you have any recollection of attempting to get those records from the phone records from that landline?
My recollection, and of course, the court file and the trial video would be the ultimate answer to that, I think. But I looked for landline records, I looked for cell records, and I think there were actually even 2 different cell companies. So I had records from 3 different phone sources.
But you don't recall if you specifically had the landline records from that home during that time?
Are you talking about the home of Chastity Hagen?
Yes, and her mother.
I believe we got records from Hagen, but it may have been her mother's address. I think her mother was Wanda, if memory serves me correct. I think her name was Wanda, and that may have been the landline records that we got would have been under the name Wanda Hagen rather than Chastity Hagen. I think Chastity Hagen had a cell phone.
Would it sound unusual to you if you learned that the landline records had been unavailable by the time they were asked for?
Would it be unusual?
Yes, do you, does that ring a bell to you?
Well, my experience with phone records is, that again is something that can be a little bit spotty. Because sometimes you try and get records and are told that they were destroyed. In which case I would try and get somebody to testify to that fact. And I don't know, I don't recall whether that occurred. I don't believe that that occurred. But I think if a landline was involved, it was probably the one for either Chastity Hagan or Wanda Hagan.
I don't believe I have anything further.
A moment, Your Honor.
Okay. Wait.
Mr. Buckin, I realize that it's been several years since all of this occurred. Do you recall during your preparation for the trial, going over the interrogation that was recorded by the officers and Mr. Smith on the day after the killing?
That was my usual practice was to go since you shouldn't be looking at them. So that's my usual practice, and I believe I've followed my usual practice in that regard.
Are you able now to recall any specifics in that interview that related to telephone calls?
I don't recall any specific statements that were made in regards to telephone calls. And I'm not sure who you're saying. Are you referring to statements by Mr. Smith or the detectives?
Yes, sir.
No, I don't recall.
All right, thank you.
Do you have any redirect?
I do not.
He'd be excused? Would you like his presence to remain present in case something else comes up during the hearing?
As far as I'm concerned, he can be excused, but he's not under my subpoena, so.
May be excused?
I Well, I'd like Mr. Button to be subject to recall as well as.
May
Mr.
stay
Smith.
subject to recall, Mr. Booker. You may stand down.
I'll stay and take a seat in the gallery if that's okay, Your Honor.
Fine. Want to call your next witness?
No further witnesses for the defense.
They've announced closed. Do you have witnesses?
I call Russell Decker.
You may stand down.
Thank you very much, Your Honor.
Russell Deckard. Raise your right hand, please. You swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
I did.
Have a seat. State your name, please.
Russell Decker.
You may inquire.
Mr. Decker, what is your profession or what was your profession back in 2012?
I was a detective assigned to Post 15 in Columbia.
And were you one of the officers that was assigned to investigate the killing of Brenda Howard?
I was, along with Detective Ricky Brooks, who's now deceased.
Do you recall an interview that you and Detective Brooks had with John Smith on the next morning following the murder of Mrs. Howard?
Yes, sir.
Have you had the occasion recently, this morning, for instance, to have listened to that?
I listened to portions of it this morning. Yes, sir.
From what you heard, is that an accurate recording of the interrogation that occurred that morning between you two detectives and Mr. Smith?
Yes, sir.
Were there portions of that interrogation that related to telephone call?
Yes, sir.
Who was the officer mainly talking to him about that?
Most of the time it was myself.
Did you hear that part of the interrogation played this morning?
Yes, sir, I did.
And from what you heard, is it a true and authentic recording of what actually occurred?
Yes, sir.
Now, Amber, Judge, I want to play a portion of the recording.
Okay, the objection's ordered, been authenticated.
I'm sorry, Judge, I didn't hear what.
I
what you
said, without objection, I'll allow it to be played. He has authenticated it. He's listened to it. He was there, was present.
Judge, I don't necessarily object to the claim, but I would object that, I have been very careful to stay within the confines of the issue that the Court of Appeals sent back for this hearing. And that issue is specifically what was told to Mr. Smith's attorneys. So I think we are getting far afield from that in discussing what he told the police.
This will relate to telephone calls, right?
But it won't
You're
relate
saying
to
that we
what he
should
told
not
his
get
attorneys.
into the validity of what he told his attorneys, but just whether he told his attorneys this or not. Is that what you're saying?
The validity may be relevant, but whether he made these statements to the police are not relevant. And that's a fine distinction, I know, but it seems that Mr. Hunley is going, maybe I'm incorrect, but it seems like he is going towards it being at issue whether Mr. Smith gave all of his potential defenses to the police. And that is not the issue. The issue is what he told his attorneys.
But it's please, it would be a statement that would contradict Mr. Smith's testimony here today.
I'm going to listen to it, see what it says. Go ahead.
All right, and start at 32, I believe. Then I'll tell you when to stop.
Hello? Where are we on this?
I don't know, Your Honor. My technology skills don't go this far.
He had went to sleep and it's taken forever to recognize it.
Let's go off the record until the technology gets adjusted here.
You do?
Right, playing, but I don't know where this is.
Press on the fact to try to get title on.
Okay,
Remember the guy thing? Puts that car there, puts him there.
Oh, the neighbor, yeah.
Yeah.
okay.
not
You want to stop it now? Stop.
Why?
Is that what you want to get on the record there?
Yeah.
Okay, let's go back on the record. Turn that volume up, please. We're on the record now. Let me proceed.
Mary's house, seriously, I did not go down there. I went two places yesterday. I went to Cash Express in Lafayette to try to get title on, and I went back home.
That's not exactly true. Do you have a
Yes,
cell
sir.
phone?
Chastity's.
Did you have it on you?
Yeah, I had it on this morning.
When they arrested you? They arrested you this morning?
Yeah.
Okay. Cause then I'll tell you what we're gonna do on that. These little cell phones, and I've got one back there.
Sir.
Hold on. Every place that phone goes, it's looking for a tower. It's called
Yes,
pinging.
sir. Hello.
Well, if I take in that area, there's 2 cell phone towers or 3. I don't remember which it is. It doesn't matter. If your phone is in this area, if that lady's trailer is right here, and your phone is here, it's going to hit that cell tower. Well, it's going to tell me he is within this amount of degrees. That phone. Now listen. There's your trailer. There's the cell tower, and that may not be exactly where the cell tower is at. We're just using this for an illustration. But when that phone pings, it'll say, this is the closest tower, and this is at this degrees at this time. Okay? If you move and drive over here, well, then this cell tower will say, well, at this time he was here. And if you drove around that cell tower, it'll say 2 or 3 minutes later, say, well, he's over here. And actually, I track people with these cell phones as long as they're on. Track them all the way to Colorado. On a dope deal.
I understand that.
So, you said you had a cell phone. So now I got you.
I had that cell phone this morning.
You said you had a cell phone. It's on the
I said
tape.
I had the cell phone this morning, sir.
Well, I'm gonna put that cell phone there. I'm gonna put that cell phone there, and that's it. That's
cell phone. Chastity had her cell phone. Yours.
Yeah, and
But
Chastity had it
this
when you
morning-
and her went in there and beat that old woman to death, too.
Sir.
How about the phone call you made to her daughter?
I'd like to talk to her dog. No.
And you know her family because you.
You
called it private.
No, sir.
on another girl. Yeah.
No, sir.
Yeah, and when I get those cell phone records later on this afternoon, I'm gonna be able to prove that. Even though you blocked that number, it's still gonna show up. So, and then I'm gonna do a voice line up with you, and then that lady, the daughter, is gonna ID your voice, and then that's the nail in the coffin, young man. That is the nail in the coffin.
Your Honor,
I can't sit here and tell you I was down there yesterday when I wasn't.
Your Honor, yeah, I need, Mr. Vanderpool to go to hour 1, 17 minutes and 30 seconds. 30 seconds.
Still don't know what's wrong or what happened.
It is. And I'll never bother that one. I've never bothered that one. You know, and, I want to do 2 or 3 years, him sitting there in a stinking ass jail for something I did not do. Something I did not do. And I don't expect you to believe that for 1 minute. Because you got your mind made up. And it ain't about the evidence, whatever, you know, you can call it anything you want. But I'm telling you right now, I'm gonna do 2 or 3 years in, jail before I go to trial. Did not do. I sure will. And buddy, if I know who.
Did you make any calls on that cell phone list?
No, sure.
You never made one call on it. You had it in your pocket, did you?
This morning, I got it, cause
Take
Chastity,
away.
no, Chastity was gone and you know, I done had it in my pocket when she come in. And I didn't think nothing about giving it back to her, so.
You know Melinda Webb?
That's one I don't talk to. That's Chastity's phone call.
Were those two conversations about the telephone call? And they're talking about Chastity's phone, is that correct?
I believe so, yes, sir.
And he said that Chastity had the phone all day yesterday, but he had it this morning. That's correct.
I believe so.
And that he didn't make any calls on that phone yesterday. That would have been the day of the murder.
Correct.
But that the phone was in his pocket. He had it all along. Chastity didn't have it.
Correct.
Objection, Your Honor. That's not what I heard on that tape.
Well, I'm a little confused my own self here. Now, let me ask you some questions just for my edification.
Me?
Yeah.
Yes.
Your theory is that Mr. Smith said that he made phone calls from a landline to Chastity's phone. That's what he wanted investigated, correct?
That's one of the things. Most of what I was presenting testimony today about of other people was that he made calls from the landline to Loretta Walker.
That's what I just asked you.
You said Chastity Hagan.
Well, so were these other phone calls that you alleged made from a landline? We're talking about a window of opportunity when he says that he has an alibi because the crime was being committed there and he was at a place where he was making calls from a landline.
Correct.
At that time period.
Correct.
Who does he allege that did he tell him he was making phone calls to? Was one of them to Chastity Hagan?
I believe there was his testimony today was that there were calls to Chastity Hagan.
So this is relevant here as to whether or not he had Chastity Hagan's cell phone at a time period when he was saying he was making a call from a landline to that cell phone.
That's exactly
Well,
right.
I'm just trying to
Well, Judge,
understand this. I'm just trying to understand. I'm not saying
I'm just trying to answer your question.
okay, well, I won't interrupt you then.
I mean, relevance is a very low standard. So is it relevant? I guess, but the fact that there are calls coming into a cell phone doesn't tell us where those or who made those calls.
I kind of understand that.
So the point.
Let me ask
that-
you, I'm trying just to get some context here. Okay, just some
That's
context.
what
It's
I'm trying-
hard for me. It was hard for me to follow what that said. And then I don't know whether I agree with what the witness said, that it said what he was asked. He responded to the question. But for context here, the calls that your clients depended on to establish his location were made from a site that had a fixed landline.
Correct.
And that's his alibi.
Correct.
Okay. And there were phone calls made to 2 different people.
Correct.
One of them was Chastity Hagan.
Correct.
But this testimony that your client stated is that he had Chastity Hagen's phone during that time period.
That he just stated there.
Yeah, that's what I understood.
What I heard him say multiple times was that he had that phone on his person the morning of his arrest.
Well, I heard
which
that
is the
portion of it
next
too,
day.
but
And he also very clearly said she had her phone yesterday.
I
which is the
didn't, I
day in
didn't hear it
question.
like that. I thought he said he gave it back to her is what I thought.
That morning.
Well, he had
Or
to
no,
have, that
I'm sorry,
had,
he
that's
said that he
right. That's what
didn't-
I thought
he
he
said he
said.
didn't
Let's
give it
play it
back to
again. Let's play that again.
No, this one, I think. This portion.
Okay. But it is what it is. And I'll never bother that one. I've never bothered that one,
Turn it up if you
you
can.
know? And, I want to do 2 or 3 years, sitting there in this stinking ass jail for something I did not do. Something I did not do. And I don't expect you to believe that for 1 minute. Because you got your mind made up. And it ain't about evidence, whatever, you can call it anything you want. But I'm telling you right now, I'm gonna do 2 or 3 years in, jail before I go to trial. Something I did not do. Sure will. And buddy, if I know who.
Did you make any calls on that cell phone yesterday?
No, sure.
You never made one call on it. You had it in your pocket.
This morning, I got it. So
Take
Chastity,
away.
no, Chastity was gone and I, I done had it in my pocket when she come in. And I didn't think nothing about giving it back to her, so.
You know Melinda Webb?
That's one I don't talk to. That's Chastity's phone call.
You know her.
Yeah, I know her.
Know her.
Cause my kid's mama, that's her first cousin.
Okay. You know a, Willie Strode?
You want to hear the second call, Judge?
Judge, I'd like to point out that what I heard him say there was he was asked, did you make calls from that phone? And he said, no. And they said, you said you had it. And he said, this morning.
I heard him say he gave it back to her. Play it again.
Judge, I don't know how else to.
Well, maybe I'm too thick to understand what you're telling me here, but I'm hearing what I'm hearing here. He said that he didn't make any phone calls on that cell phone, but you've never alleged that he made any phone calls. You're making the allegation. He made the allegation that he made phone calls from a landline to that cell phone.
Yes.
So what I'm trying to determine is when he had that cell phone. We know he had it on him that morning the day that he was arrested. He had the cell phone on him. We've established that. I'm trying to listen, anytime there's these interrogations, there's these interruptions, with the interrogation techniques and things. I want to play just that portion of it to say when she had when she had the cell phone and when he gave it back to her. Now, I'm thinking I'm hearing something like that. Play it one more time. I don't want it from the beginning, just that portion of it.
Sure will. And buddy, if I know who.
Did you make any calls on that cell phone yesterday?
No, sure.
You never made one call on it. You had it in your pocket.
This morning, I got it. So
Take away.
no, Chastity was gone and I
you know, I done had it in my pocket when she come in, and I didn't think nothing about giving it back to her, so.
Okay, stop it right there.
That's one
Stop
of
it
them.
right there. Okay, now what I heard him say, that when she came back in that morning, he already had it in his pocket and he was thinking about giving it back to her. Did you hear that?
Judge,
Did you hear that? I'm just asking you if you heard that.
yes, but the
Okay,
way
well, I'm
I
gonna give you,
hear it
I'm
is that
gonna
that
give
is
you,
all
wait,
related.
wait just a second. I'm gonna give you plenty of time. Don't act so frustrated. I'm gonna give you plenty of time to explain it. I'm just asking if we heard the same thing. Okay, did you hear that?
Yes, but that
Okay,
is
now
not
you
the
can explain
complete.
it. Now go ahead.
Judge, he says what you said, yes, but he also, seconds before that, said this morning, and then everything he says after that relates to this morning.
Okay. Y'all have anything to say about it?
I heard what I heard, Your Honor.
What did you hear?
First call. He said I had the phone call, I had the phone this morning, that's the day after Miss Howard was killed. Then he said Chastity had the phone yesterday. Then the next question was, did you make any phone calls? No, I sure didn't. Sure did not yesterday. The phone was in my pocket. I had forgot about it.
Okay, go ahead. You want to ask this witness any more questions?
No, Your Honor.
Would you like to inquire of the witness?
Yes, thank you. Sir, who employed you at this time?
Kentucky State Police.
Okay, so were you at any time working for the defense?
Oh, sir.
Okay.
No, ma'am.
Ma'am.
I'm sorry.
So it
I
was not
apologize.
your, what, or maybe it was it your job to prepare a defense for Mr. Smith?
I was just there to present the facts to the Commonwealth Attorney's Office.
Okay, was it your job to develop defense strategy for Mr. Smith?
There again, I was just to develop the evidence and report
So
the
that's
evidence.
no.
That's no.
Were you privy to conversations about defense strategy?
No.
Did you ever discuss defense strategy with Mr. Smith's attorneys?
No.
Nothing further.
And we may have one other thing, but I need a few minutes.
Okay, let's take a brief break. This is a bathroom break. Mr. Smith, if you need to use the restroom or everything, you just tell those people and they'll make an opportunity for it. So we'll take a 10-minute break. Let's go off the record.
That's all I do. I'll bet more out of housing. Feel bad. I've been everywhere, yeah. That would be. I'll let you back in your. You can tell me come over here, like I feel like I would speak so bad. I think it's just kind of the same. Very rare. That's what I would. Oh, you can come back, like something really will even about, you know, that's like 30 more minutes. Yeah, already, because I'm not. That's so big.
My stepdaughter on that phone. Let's go back.
Thank you all. You guys.
Hey, we bring them, you bring them, put them in the car. I really need that one race. I really do. There you go. Not there. Honestly. Yeah, you know. All right, I'm going to get it. I really do. I do need. I want to go. Very cool. I don't get it. Regulations. Now, I would say good luck to the eyes.
Thank you for being here.
Oh, I'm glad.
And I'm glad they were able to find the file yesterday.
What?
I'm glad they found the file yesterday.
Oh, they did. They did. It was very helpful because my memory's not as great as it used to be, so. But a lot of it came back to me and said, that's how I want things. See where. Anyway, where the hell you live? North, yeah, you've been there for a while. Well, listen, because like, I gotta try to tell you it as easy as you can. But it's tough. It's real tough. I know.
Unsafe drive fast.
What's that?
So drive safe.
Yeah, I'm gonna stick around in case somebody calls.
Okay.
I'm down in there a couple minutes later. See, down more home knows I did not done this. So I always thought that, but then it's this morning, I think it's something there, but I'm playing court. So. Today's Saturday. I'm saying sorry. You need me back too. Some 7 o'clock. She said, "God, come on, let us go." You should have said that. It's next time. What's up? Nice. Oh, you mean the birds on there? What's back to our barn today? You know, but just turn down the road there. I think that's what I'm going.
I'd like to run one to get across to the beach. I think
Still say, cut Russell, who's now leave? I will. You can go get mine and hit me at the end of that. I can throw it in the window. I can buy it for you. And get me out of here. But I mean, I want to be in my truck by 12:30. That's 9 minutes. You gonna do that? I'd like to be in too.
Say, like Melinda or Linda? What is her name? Melinda or Linda? Oh, good. Come up here. Like, is it Melinda or Linda? Who's Melinda Ware? That her?
No, no, that's another person.
It's what?
That's another person.
Okay.
Okay. Loretta.
Where did Mr. Buffett go?
Derek Michael's going to get him.
Oh,
Same person. They married.
Okay, y'all ready to go back on the record?
Yes, Your Honor.
Okay, let's go back on the record. We've had a short break by way of explanation. We've had a short break in the Commonwealth asked. And Mr. Decker, are you still on, is he still on the stand?
No.
Yeah.
I'm,
Are you gonna call somebody else?
yes, I'm gonna recall Michael Buck.
Okay,
Am I free to go?
I don't know.
Okay, am I free to go?
I hope, yes, go ahead. Get on your out, man.
No, Jack.
Okay, you may be released. Thank you.
Thank you, Russell.
Mr. Buck, you realize you're still under oath?
Yes, Your Honor, I do.
Go ahead.
Mr. Buckin, based upon your recall and perhaps some that's been jogged here today, did you investigate or cause to be investigated the potential alibi issue presented to you?
I can tell you what I did. And I want to try and avoid any hearsay, but I instructed Josephine Guy to contact Loretta Decker and to interview Ms. Decker. Is that what you wanted to find out?
That's that would be part of an investigation process, would it not be?
What would that entail? Is that what you're asking?
Did you investigate or cause an investigation to be made on the alibi issue? The answer would be
yes.
Yeah. From the information provided to you as a result of the investigative process or efforts, if it had established an alibi for the defendant, would you have used it?
Yes.
Did you, Mr. Buchan, as kind of a summary question, did you see anything from the phone records or the investigative reports furnished to you that would have established an alibi?
Well, I want to make sure my answer is clear, but I think I would have to preface my answer by saying that phone records in and of themselves don't say where a particular person was at a particular time. It is records of telephone calls and different people can use the same phones. Do you understand what I'm saying?
Yes.
So I think it's difficult for me. I think particularly because of my profession, to come to a conclusion that I can't say that there's evidence to make it possible to come to that kind of a conclusion.
Well, we have established that you did institute or cause an investigation to be made.
Yes.
Based on,
Let me ask the question here too. Get these. Was Loretta Decker, she was subpoenaed, right?
Yes, Your Honor.
She was subpoenaed, and when the trial didn't go, you subpoenaed her the second time.
I don't know. I'm
I
sure
thought
I
that's
would
what-
have, but I don't know
Yeah.
for sure, for
And
a fact.
she
Yes.
she didn't show up for the trial.
No, she did not.
And you didn't ask for continuance because she didn't show up.
I don't know if I did or not.
You
I
have no
don't recall.
recollection of that.
I don't recall whether I asked for
And,
continuance.
but I think you
based
previously
upon that.
testified that if she hadn't had known something of relevance, you wouldn't have had her subpoenaed. Did you
Yes,
say
Your Honor.
that? And if you had her subpoenaed, and for whatever reason, do you remember the reason you decided to go on with the trial with her not being here?
I'm trying to relect my thought processes for a moment, Judge. I don't want to
If you don't remember, you don't remember.
I don't remember.
Okay.
We-
Okay, y'all can continue. I just want to get that.
I have no further questions.
Do you have any inquiry of him?
I don't believe so, Judge. After your follow-up questions, I don't believe I have anything. further.
Okay, now, who is the other, so I can maybe ask him one other question. Who was the other landline call? One of them was the name, who was the other landline call?
There was one to, well, I think more than one, to Loretta Decker Walker,
Yes,
and at least one, if not more, to Chastity Hagan.
yeah. Were those the only two individuals that you were interested in?
Yes.
Okay. Okay, thank you very much. Can he stand down? Do you have any other questions you'd like to ask him?
I do not.
Okay, you may stand down, but remain
Thank you, Your
present. Yeah. Anybody else have another witness they'd like to call?
I do not, Your Honor.
No, Your Honor.
Anybody else?
No, Your Honor.
Would you like to announce closed?
Yes.
Now, do you believe you get to make the last argument in this?
Yes.
I believe you do too.
It's so opposite of a trial. I have to stop and think, but
Yeah,
yes.
I've suffered that myself as a defense lawyer down through the years. Okay, would y'all like to make a statement?
Judge, would the court prefer, we've done it both ways. I guess more frequently we do written,
I'm going to ask for both,
Okay.
but I'd like to see, while it's still fresh on my mind and we're on the record here, do y'all have a closing or you want to just depend upon a written submission?
I'll say a word, Your Honor.
I thought as much.
I promise you.
Yeah.
The real issue
Why don't you come around here where I can hear you?
The real issue in this case is whether Mr. Bupkin and the attorneys for the defense made any kind of investigation. The proof here today shows, yes, they did make an investigation. Now, the last questions that I asked Mr. Bupkin is that based upon what he found from his investigators and what he learned, would he have used that? Could he have used that to establish an alibi? It was his judgment then and now, no, that it would not. And it's basically that simple.
Okay, thank you. Would you like to?
Yes. Do you want me to come up there, Judge?
Sure.
Judge, I do agree that the issue is really simple. I don't think I agree with Mr. Hunley on what the issue is, though.
That doesn't mean it's not difficult. Even some
correct.
simple issues are difficult, aren't they?
Yes, yes. The issue is not whether there was an investigation. The issue is whether there was a defense provided to Mr. Smith that meets the professional standards, and whether if it didn't meet those professional standards, whether it caused prejudice to Mr. Smith. So that's what the issue is, which I guess I'll retract my statement, is not quite as simple as what Mr. Hunley characterized it as. I think it is clear from the testimony that there was an investigation, that we've heard about it being directed to happen, and we've heard some about it actually happening from the investigator who testified. But we've also heard that there were steps taken to present the results of that investigation to the jury at trial, but then that it was ultimately not presented to the jury. That Ms. Decker Walker was not present in court, and that there were no efforts made to secure her presence and her testimony in court for the trial.
And Ms. Hagan was present. She testified.
Yes, and Judge, I was focusing more and have been focusing, pursuant to the briefs that were filed previously before I was on the case, on the call to Ms. Decker Walker. I believe that is Mr. Smith's contention that there were calls made to Ms. Hagan. That's a very different issue, especially since she was at some point a co-defendant in the case, but.
And these calls were made from her mother's. The stationary phone you're talking about.
Correct.
Is her mother's.
Yes.
And he was at and you're saying, he's saying kinda that he was at the mother's house and used that stationary phone to call Chastity Hagan and Loretta Decker.
Exactly.
And, okay. Well, it took me a while, and the mother's name is Melinda.
Wanda Hagan, yeah.
Wanda Hagan, yeah.
Who was dead before the trial.
I remember her being dead, yeah.
And Judge, I do think it's important to very carefully consider Mr. Buffkin's testimony. It is always the case when an attorney is testifying about a case that happened years ago, as they always are in post-conviction. There are two different things. This is what I precisely remember happening in this case, and this is what I can say my normal practice.
I'm very well aware of
So I
forgetting
just
things
want
that
to-
happened 50 years ago, or 40 years ago, or 10 years ago, or last year, because the things are not as significant to you after you've finished with a case as the case you're working on now or your next case. Okay, I understand that. I'm sure all of us that practice over a period of time have somebody, you remember that will you wrote for me and Mama? And I'll say, well, when was that? Well, that's right after she got out of the hospital. We all experience that sort of thing. But I appreciate your argument. It appears to me the 1142 hinges upon whether or not a valid alibi or an alibi allegation made by the appellant was either ignored or not properly investigated or wasn't presented. And I'm going to allow you to brief this, but let me tell you where I am right now, kind of in my mind, the reason I was asking for some of the questions. It appears to me, and I might have heard that thing wrong, but it appears to me that on the morning that Chastity Hagan came back in, that the appellant had her phone. And that he had her phone. Now, you think that it says that she handed the phone to him that day, or he got the phone that day, which was the day after the shooting took place. Well, if he had it already in his pocket, I don't know where he got it. Did she give it to, and he said he'd forgotten it was there. It appears to me that he might have, as I hear, that he had her phone all along and forgot to give it back to her. If that's the case, he couldn't have made a phone call from the stationary location if he was there because he had the phone. Now that's where, and so I want you to focus on, I'm giving you warning when you, the other thing that appears to me is if he had, as far as this Loretta Decker or whatever, there was an investigation done evidently on why a phone call was made to her from that stationary line. And she was subpoenaed, and Mr. Buffkin said he wouldn't have subpoenaed her unless he thought she had some relevant statements to made like that. But I'm a pretty experienced criminal defense lawyer, and I get in trials sometimes. And sometimes I've tried the case. I've tried some cases twice, if I was lucky enough, if I lost it the first time. And sometimes you decide and make decisions on why you don't call people. You hear something at the trial or whatever, and you know you've done the investigation and there's something relevant, and your investigator said there was something relevant. She didn't exactly say what it was, the previous investigator. So it appears to me that that someone knew that there was something relevant. If it wasn't about this phone call made from the stationary line, I don't know what else it could have been about. So for whatever reason, Mr. Buffkin decided that when she didn't show up that day under subpoena, that her presence was not necessary, or maybe it wasn't going to be ethical to present the testimony. And he didn't ask for a continuance, and he didn't call her. So that's kind of where I am right now. If you're depending on these two phone calls from a stationary line, one of the individuals was present and was subject to cross-examination, and it would appear to me that if in the appellant's mind, Mr. Smith, that he had called her on a stationary line, somebody could have said at such and so day on this date, did I not call you on this stationary line? And evidently it wasn't thought that that was relevant, and I would imagine that they could have found out where that cell phone was when the call was made from the stationary line. It would have pinged somewhere. So, I'm leaning to believe that there could have been, and actually was, an investigation made, and there could have been, lost in time, relevant reasons why a experienced defense attorney, and I saw Mr. Buffkin try this case, and I saw all the motions that he made, and in my opinion, he was very thorough. And so that's the way I'm leaning. You might convince me otherwise in this brief that you have. And the other thing about the brief is I don't interrupt you when you write the brief. So it won't take you. Well, thank y'all very much for presenting this thing, and I'll take it under advisement. And I've got this sign right here for you to say, and it says on their officer that I just took it under advisement. Okay. Thank y'all very much. This concludes the session.
I'm sorry, court have a day that.
30 days enough, 30 days, and then if I want y'all to come back to argue, I'll schedule it. And y'all get, I'll just let them respond. You do 30 days and this week?
Excuse me?
Said you worked up, you're gonna do the presentations this week.
No.
Clary?
Continue to June 12th, please.
Crawford?
June the 12th, please.
Russell?
June the 12th, please.
Fox?
June the 12th.
How much more time we got left on Fox here? Huh?
What is?
It was $3,995.
I just got 4.5 years left in my term here. I hope to finish that case out. That'd be 18 years. Be on there. Graves versus Graves.
June the 12th, please.
Turner versus Guthrie.
June the 12th.
Hammer versus Hammer.
June the 12th.
Hats versus Hatsett.
June the 12th.
Heston versus Heston.
June the 12th.
Taylor versus Houchins.
June the 12th.
Hudson versus Hudson.
June the 12th.
Jimenez versus Jimenez.
June the 12th. California.
Joyner versus Joyner.
June the 12th.
Dye versus Jones.
June the 12th.
Jones versus Jones.
June the 12th.
Page versus Page.
June the 12th.
Pennington versus Pennington.
June the 12th.
Rich versus Rich.
June the 12th.
Brown versus Scott.
June the 12th.
Smith versus Smith.
June the 12th.
Let's go off the record just for a second. I want you and you to come up here for a second. That finish the doc. No, I said,
Other one?
oh, here. Okay. Stetson versus Graves. Turn that over. You go? Good. Anything else I need to know?
The only thing I bring up is that, there was an adoption that I wasn't aware of, because I'm in the family, so you're talking about that, so you won't have the document, but it'll be a brief file.
Okay, thank you. Okay, what do we have here? Motion for visitation. We got Janie, Joe, Stinson, and Mackenzie. Right, okay.
It's my motion, Judge. Yeah, this case, there was,
Could you identify the folks? Is this your client? Who are you?
yeah, this is my client. I'm not sure if it this.
I'm Danny Joe Stinson, Your Honor.
Okay,
And what's your involvement in this?
I am the,
he's
custodian.
one of the petitioners.
Levi Garrett.
Okay. Okay, what do you have here?
Judge, it's pretty straightforward. We're just asking for a hearing. The parties all agreed a few years ago to name the Stinsons de facto custodians of the minor child.
How old is the child now?
He's 6-year-old.
And in that agreement, it was that the visitation with the parents would be as agreed with the petitioners. And that worked well up until very recently. Very recently, there's been, I believe, a breakdown and my client's not getting contact with the child.
When you want to set a hearing for?
As soon as possible, Judge. I mean, I
Well,
think it's pretty
we
straightforward.
could have had one today.
Well, I know, Miss Stinson called my office yesterday.
Are you gonna have an attorney?
Your Honor, I would like to request a continuance here today.
I'm asking you if you're gonna get an attorney.
Yes, sir.
Okay, so let's schedule the hearing. I'm gonna wait till the next rule day.
Okay.
Which is, at like let's say 1:15 on June the 12th. That give you time.
I do have a few extenuating circumstances. I think my father-in-law is in Nashville at the moment battling cancer. And,
Well, I don't know how long that will last. You know, it might last longer, but June the 12th gives you plenty of time. And, you know, I mean, today's 15th, that's a month. So, I mean, that's longer than they would like. And that's the reason I gave you longer. So you can retain the counsel, okay? Okay, and you'll do an order on that and make sure she has your correct
I was gonna
address.
say, yeah, I need that. And Judge, I know the other case, there's two cases. There are two children. One is with the Stinsons, one is with the Milans.
Yeah.
So it's the same motion for both because they are siblings. So I don't know if you want to call it and schedule it at the same time too.
Milam Loy and others versus Mackenzie Gray, is that it?
Yes.
Is the other side they hear on that?
She did not request this motion. It was all, this here.
What do you,
I don't know if any of the other parties are here. I don't see them. Loy and Raina Milam. I think Mr. Milam is the one that's in the hospital and has cancer.
Mr. Malum is in Nashville at the moment.
okay, young lady, what's your name? You got one of the children or what?
No.
She's the mother.
My grandma and grandpa has my daughter. My
Yeah.
mom and dad have my son. My
Okay, and the
grandpa-
grandparents, your grandfather's one that's
He's
has,
in Nashville.
cancer,
and
yeah.
he's gonna be there for,
well, we'll have to, is your grandmother,
she has to be with me.
well, I know, but I'm gonna schedule this on the, you know, on the 12th of June. And if she's still down there, then she'll just have to make some arrangements for her to be, somebody else to be with him on that day, if she wants to appear, okay? I mean, I'm sorry they're going through that, but I can't put it off forever, you know what I mean? And that's your daughter that they have? Who's got the daughter today? Yeah, well, I mean, when she comes home from school, so you're going, the parents are gonna keep it, okay, all right. Well, I don't see any reason why y'all couldn't share a lawyer in the thing. It appears to me there wouldn't be conflict since the same reasons that you don't think visitation ought to happen with the biological father would probably be presented in both cases. You agree with that, Counselor?
Yeah, I think that they have aligned interests, yes.
Yeah, they have aligned interests that should save you some money. Okay, thank y'all very much. Hillman versus Hillman. July 17th. Vincent versus Vincent. Vincent versus Vincent. It's a motion to transfer.
Then that group order could be signed.
transfer the case? To where? I will reluctantly agree to transfer the case to Barron County's agreed order. Is that the end of the civil docket? And then we got a confidential matter at what time? 2? Okay, we're off the record then.